both the FIRs together, which is not done by the High Grounds Police Station, and referred only one case to CCB, which shows that there is hand in glove with the respondent number 2 and the police. Our allegation is this High Grounds Police has always been colluding with these people.
Yes.
And my lord, so far as one more order, if your lordship kindly comes, my lords, at 184. This is again that lady against whom they say we had molested. 184 is another criminal petition, my lords.
That is stayed.
Yes, in that, please see the observation there, my lord.
That's pending.
Pending. Relating to the same.
Yes, sir.
Same issues, my lords, where they say.
I've seen. Yes.
That is how, my lords. In the judgments, we have given paras which say, 482, your lordships can see whether it's a vexation purposely done. Though allegations are there, and none of the ladies complained. And he is not.
Mohammed Ali.
We have given that.
Yes, sir.
Lord, I have filed a compilation. Yesterday, I placed it on record.
Yesterday.
Yesterday, I have given.
Yes, sir.
Lord, B report 135, complaint what they registered. B report is filed. That they have not produced. Lordship gets at page number 3.
In the complaint registered against you, B report is filed.
B report is filed.
Hmm.
Lord, in this case, it's not in dispute that the petitioners, they went to BTV premises. That's not in dispute. Then the police were called. That's not in dispute. Whatever has happened, Lord, it's all recorded in CCTV footage, CCTV. That footage screenshots I have produced.
Hmm.
Now, my lord, the 164 statement of 2 women employees are recorded. Prima facie, there is a material for 354A, assault. My lord, let there be an investigation. My lord, their presence is there. My lord, there are cases and counter cases. That's not in dispute. Lord, there is an observation by this honorable court against the petitioner that they manipulated records of Vijayanagar police station. A direction was issued to ACP and DCP. They held an inquiry and submitted a report that the entire records of the police station was manipulated. My lord, regarding that, a complaint is also filed
Against them.
against them. They only made that they file a writ petition before this honorable.
Which case is that?
Lord, connected to this.
Where is it? Which
Lord,
petition?
I have not placed it since they referred to some
Then
other
how can
complaint.
you?
No, I
contain-
will also place that on record.
Place it.
Not the entire compilation what they have filed. It's not connected to the case. It's connected to something else. Not the fact remains on the date of incident. At that point of time, they were there. That's not in dispute. Then it's all recorded. That is what the investigating officer observed. Not what are all the case and counter case, I may also be permitted to file a compilation. I will do
Please
it.
do.
I'll place it, what they have done, how they manipulated records. It's all on record. A direction was issued to DCP and ACP to hold an inquiry. They submitted a report. In fact, it is the petitioners who are known for manipulation of records.
Oh.
As per the investigation done by the ACP and DCP based on the order passed by this honorable court. That's also on record. I'll place it.
Yes. Heard the learned senior counsel K.N. Panindra appearing for the petitioner. The learned senior counsel taking this court through the documents as well as certain documents produced along with the memo hakadra, a certain
Synopsis with this.
as well as the
Synopsis.
synopsis to contend that the second respondent complainant is in the habit of manipulating records, and the high grounds police station, the police personnel of the high grounds police station are hand in glove with the complainant or whomever the complainant represents. The learned counsel for the second respondent complainant would counter this by contending that the petitioners in fact are known for manipulating the records. Therefore, it is a case of manipulation versus manipulation. The records of such manipulation by the second respondent will be placed on record by the next date of hearing.
May I submit, my lord, call for that CCTV footage.
You
that-
first produce ಮಾಡಿ ಏನಿದೆ manipulation.
I'll produce that. There is a direction by this honorable court, investigation was
You
done.
produce all
I'll
that.
produce it, my lord. Meanwhile, may I submit, my lord, that the CCTV can be called for. That is,
You produce it, we will see if it is needed, we will do it.
that is in domain of the high grounds police. Let them produce. Therefore,
ಅದು ಆ ಕಡೆ ಅಲ್ಲ, ಈ ಕಡೆ ಇದ್ದಾರೆ.
IO kept it in the pen drive, my lord.
let
drive
it
ಆ?
be produced.
Recorded and,
First ಅವರು
Let it be produced,
ಅಲ್ಲ,
my lord.
manipulation
ಇಲ್ಲ ಇಲ್ಲ
records
ಫಸ್ಟ್
ತಗೊಂಡು
ರೆಕಾರ್ಡ್ ನೋಡ್ತೀನಿ ಆಮೇಲೆ ಪೆನ್ ಡ್ರೈವ್ ಕೇಳೋಣ.
please.
ಪೆನ್ ಡ್ರೈವ್
ಪೆನ್ ಡ್ರೈವ್ ನೋಡಿದ್ರೆ
ಅಯ್ಯೋ ಬೇಡ
ಗೊತ್ತಾಗುತ್ತೆ.
ಈಗಲೇ ಪೆನ್ ಡ್ರೈವ್ ಆಮೇಲೆ ಬರ್ಲಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಅದನ್ನು ಕೊಡ್ತೀನಿ. Not on Monday, kindly have it on Tuesday, my lord. Monday, I have some difficulty.
I did not say Monday at all.
I'll leave it to your lordship.
It's on 21st.
Please, ma'am.
Yes, list on 21st in the fresh matters list. Sarvada, for further hearing at 4 PM,
21st is Sunday.
22nd, sorry sir. 20. ಅವತ್ತು ಅವ್ರು ಹೂ ಅಂದ್ರೆ ಓಕೆ ಅಂತ
ನಾವು ಬರ್ಬೇಕಾಗತ್ತೆ ಅಂತ.
Yes, next. Sufficiency of notice.
Sorry, my lord. Sorry to.
Ah.
This is one matter lordship said 3:30 to remind, therefore I am.
3:30, yeah? I'll just finish these orders. I'll run through the list. What is that? How 3:30 madam?
68.
Which matter, sir?
Myself and Mr. 113, my lord. There is a 114. In fact, lordships,
114.
yes. That is more a civil dispute.
No, why, what is the urgency?
Loan agreement between two companies. my lord.
I'll take it.
Yeah.
I think weather is good for a coffee, you can go and come. I'll take it at,
No, no, doesn't.
I'll take it at 4 or 4:15.
But lordships, but let us to remember, recall, therefore what I mentioned.
No, no, no problem.
that's what they-
I'm running a little slow today.
You know,
Yes. Yes, 67.
68.
I'll take it at 4:15, sir. ನಿಮ್ದೆ ಅದೇ ಅಲ್ವಾ?
ಹೌದು.
ಹಾ.
ಹೌದು.
Time for coffee is enough.
Yes, yes,
Yes,
of course.
Yes.
68.
Sufficiency of service received. The report indicates that the notice is received by the second respondent's mother on behalf of the second respondent. Therefore, the registry to print the name of the second respondent and show the second respondent as served. Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, interim order has to be granted.
Has to be granted, can't be granted. Wait, list on Monday in the fresh matters list. Yes. Furnishing PF a week's time to do the needful.
Please, one day. And interim order may be.
ಇಲ್ವಾ?
ಇದೆ.
ಇದ್ರೆ
Please,
madam, 2 weeks to do the needful. Interim order granted earlier, stands extended to the next date of hearing.
please.
Same. Interim order ಉಂಟಾ? ಇದ್ರೆ ನೋಡ್ಬಿಡಿ madam. Yes, next.
My lord, I may be permitted to delete third respondent. His presence is need not.
Delete?
Third respondent.
Memo ಹಾಕಿದ್ದೀರಾ?
My lords. Memo be taken and.
Ah. Counsel of the petitioners filed a memo for deletion of the third respondent from the array of respondents.
Kindly have it on.
It is deleted at the risk of the petitioner. Interim order ಇಲ್ವಾ? Monday fresh matters list.
Right.
Next. Post immediately, Mahesh,
My lords,
ಏನಿದೆ?
in this matter taking 1 minute, my lord.
Ah.
The lordship may kindly says allegation is the petitioner advocates changed the, before presenting the petition, address. ಅದಕ್ಕೆ address change ಮಾಡಿದ 468, 472, 420, and your lordship may kindly turn to page number 42.
Interim order ಇದೆಯಲ್ಲ sir.
ಎಲ್ಲ ಇದೆ. Just I want to bring to your lordships.
ಅಲ್ಲ interim order ಇದೆಯಲ್ಲ.
ಇದೆ. ಅದಕ್ಕೆ reinvestigation,
Reinvestigation.
ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿ reinvestigation, ಅದೇ ರಿಪೋರ್ಟ್ ಸೇಮ್ ಮೆಟೀರಿಯಲ್ಸ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್. And your lordship may kindly see the petitioners.
ಒಂದ್ ನಿಮಿಷ.
This is more than the I meet, man.
What is all?
More than the I.
Why would they do all that? You'll be waiting for a chance to pounce upon.
I will
Please,
not do
please.
so, but this
I know
is
this is a
really
classic
very-
example of that.
absolutely, my lords. And your lordship may kindly see one of the petitioner.
Oh,
Ah.
this complainant. Yes,
Yes, so therefore, I may be permitted to take hand notice also.
the fourth petition had appeared against him. That is why.
Aste, which hunting? Absolutely nothing but,
I have held that. Supreme Court has confirmed it.
yes, my lords. So therefore.
Therefore,
uh,
we'll adjourn the matter.
Allah. My request is I will take out a hand summons also.
ಇನ್ನು ಸರ್ವಿಸ್ ಬಂದಿಲ್ವಲ್ಲ?
ಅವರು ಐ ಗಾಟ್ ಸಮ್ ಅದರ್ ಇನ್ಫಾರ್ಮೇಶನ್ ದಟ್ ತಗೊಳದ್ ಹೊಡೆದ ಹಿಂದೆ ಮುಂದೆ ನೋಡ್ತಾರೆ. ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ಸ್ ಅದ್ರೊಟ್ಟಿಗೆ ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ಸ್ ತಗೋತೀವಿ.
ಅಲ್ಲ, ಇಟ್ ಗೋಸ್ ಬೈ ಪೊಲೀಸ್.
ಹೌದು.
ಇಫ್ ಇಟ್ ಡಸಂಟ್ ಯಾಕಂದ್ರೆ ರಿಪೋರ್ಟ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ
Very well. Very well.
The post immediately after service of notice upon the second respondent list this matter on 24th at
Interim
3:30 PM. Interim order subsisting shall continue till the next date of hearing.
Bless.
73. My lords, it's a transfer petition roster idalla, my lords, by mistake illi bandu. 20.
ಇದನ್ನೇನ ಮಧ್ಯಾಹ್ನ ಹೇಳಿದ್ವಿ.
Please,
Yes. 407. The matter be placed before the bench having roster as it is by mistake listed before this court.
interim order.
Interim order subsisting shall continue till the listing of the petition before the bench having roster.
Much up.
Yes.
The petitioner here is this.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಏನು
ಇಲ್ವಾ?
ಇಲ್ಲ. I
Why?
have retired.
You have retired?
Yes. At the
ಮತ್ತೆ
verge of
ಮೆಮೊ
retire-
ಎಲ್ಲಿದೆ ರಿಟೈರ್ಮೆಂಟ್ಗೆ?
ಸ್ವಾಮಿ,
ಮೆಮೊ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ. The petitioner has retired. from service.
Petitioner is
Sorry.
retired. I have retired and
Petitioner is retired from service.
yes.
The modus operandi, please, my lords, of the second respondent is
Hmm.
wherever my lords officers are retiring, he will go there, my lords, file certain RTA applications,
Hmm.
then take them, my lords, and go up to the local.
At the time of retirement.
At the time of retirement, everywhere.
ವೈ
He's a
ಸರ್, ಬೇರೆ
criminal.
ಮುಂಚೆ ಹೋಗ್ಬೇಕು ತಾನೇ ನೀವು?
ಮುಂಚೆ
ರಿಟೈರ್ಮೆಂಟ್ ಯಾಕೆ
ಬರ್ಬೇಕು.
ಹೋಗ್ತೀರಾ?
Now that is his modus operandi everywhere. He's been doing this, my lord, that is. his
ಈಗ ಏನ್
character.
ಬೇಕು?
ನಾನು interim order ಇಲ್ಲ, ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ ಎಲ್ಲ ಪೆನ್ಷನ್ ಎಲ್ಲ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ. I am ready for arguments. Anytime my lords may take it up. ಈಗ
Yes, sir.
Kindly have it on next week, members. I will file objection.
You will file objection.
ಅಂಡ್ 1 year ಆಗಿದೆ ಸ್ವಾಮಿ, ಅವ್ರೇನು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಿಲ್ಲ.
Yes, sir. INV papers.
Lokaik.
The
Lokaik.
ಲೋಕಾಯುಕ್ತ
ಲೋಕಾಯುಕ್ತನ
Lokaik.
ನೋಟಿಸ್ ಯಾರಿಗೆ ಹೋಗಿದೆ?
ಕಂಪ್ಲೇಂಟ್ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲಲ್ಲ,
Latif.
ಲತೀಫ್ ಹೋಗಿದೆಯಾ? You are appearing for whom? Latif.
Latif.
The post immediately after service of notice upon the second respondent complainant. In the meantime, there shall be an interim order of stay of further investigation qua the petitioners till the next date of hearing. List the matter on 26th. Next,
25.
Petitioner,
non-compliance.
is a judicial custody in petitioner, that is
Yen-
child marriage act, that is.
Why do you get the parties? ನಾ ಹೇಳಿದ್ನ
Last case.
ಮತ್ತೆ?
ಜೈಲಿಗೆ ಹೋಗಿದ್ರು, ಬಟ್
ಆ?
ಆರ್ಡರ್ ಇದ್ರೆ ಮಾತ್ರ ಮ್ಯಾರೇಜ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ತೀವಿ ಅಂತ ಇದ್ ಮಾಡೋದು ಜೈಲ್.
ನಾ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ನಲ್ಲ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸಿ ಅಂತ.
ಅದೇ ರಿಜಿಸ್ಟರ್ ಮಾಡೋ ಜೈಲಲ್ಲಿ ಇದಾರೆ ಸ್ವಾಮಿ, ಅದರಿಂದ ಮಾಡ್ಸಕ್ಕೆ ಸಮ್ ಪರ್ಸನಲ್.
Why I told you to get it done, cooperate with that if it is needed.
Inform
ಆಮೇಲೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದ್ರೆ ಮಾತ್ರ
on
ನಾವು
the
ಇದು
last
ಮಾಡ್ತೀವಿ.
occasion, there is order just directing them to get the marriage registration.
I cannot say register the marriage. I can only say that you get the marriage registered.
ಮಾಡಿಸ್ತೀರಿ.
15 days
Please don't keep the parties present unless I tell you.
Please.
Yes. ಇದು ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ನಾವು ಪೋಕ್ಸೋ ಮ್ಯಾರೇಜ್ ಅಲ್ಲಿ? ಯಾವತ್ತು? 16th ಹಾಕೋಣ. ಎಲ್ಲ 16th ಹಾಕ್ತೀನಿ.
Kindly to direct
15th.
jail authority ಮೇಲೆ produce.
Huh?
I went to jail, marriage, register the marriage ಮೇಲೆ.
You Tell the authorities to
Court.
get I can't pass a direct order on that. Yes,
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದ್ರೆ ಮಾತ್ರ ನಾವು ಇದು ಮಾಡ್ತೀವಿ.
ಅವ್ರು ಹೇಳ್ತಾರೆ.
Please.
Yes. Next,
76.
post immediately after service of notice upon the second respondent, interim order if any shall continue to the next date of hearing.
77.
Same order. Same order.
Prepare first.
70?
8 million. Filed wakalat to respond
Learned
number two,
counsel
my
so and so undertakes to enter appearance for the second respondent registry to print the name of so and so is appearing for the second respondent. Interim order ಇದೆಯಾ?
Posted on 19th.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
ಇಲ್ವಾ? Monday fresh
But
ಮಾಡ್ಸೋದು.
they have not
19th.
served,
ಯಾಕೆ?
ನಾನು ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗ್ಬೇಕು ಹೈದರಾಬಾದ್ 19th.
ಹೈದರಾಬಾದ್ ಅದ?
19th.
19.
they have not served a set of papers, my lords.
Petitioner to serve set of papers upon the foresaid council. 19th ಬೇಡ 22 ಆಗ್ಬೋದಲ್ಲ?
ಇಲ್ಲ
ಮತ್ತೆ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋಗ್ತೀರಾ?
19th.
ಆಯ್ತು 19.
Date.
78 ಯಾವ್ದಿದು? ಈಗಾಗಿದ್ದ? Yes.
With my lord's permission, I am appearing online. My lords, this is a fresh matter.
Interim order ಇದ್ರೆ ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
My lords, this is a fresh matter coming up for the first time. There's no order that's been passed. It's an intermediary that's been whose account is being debited for 18 lakh rupees.
Office
Which are-
objections. 1 minute, sir. It's
Please.
come on office objections. There are
Please, ma'am.
10 office objections.
Yes, my lords.
Comply with
The
it. I'll
first-
post it on Monday.
My lords, the only difficulty is objection number 1. It is the address of the complainant. We are not parties to the FIR. We are not parties to the proceeding. Hence, we don't know any address. That's why we are trying to serve him through his
Now,
bank
you want
account.
me to pass orders on every office objection?
No, my lords, that's
We
the
will
only.
adjourn it by 4 weeks.
My lords, I'll take my chances on Monday then. But that's
Yes,
the
sir.
difficulty I wanted to be. I
The
want-
office objections, except at serial number 1, shall be complied with by the next date of hearing in the next 2 days. In the event the office objections would stand complied, the registry is directed to list the matter on Monday in the fresh matters list without a memo from the court. Yes.
Deeply obliged.
Next.
There is no entry.
For respondent number 2 in
There
this
is
case,
no
my
entry
lords.
model.
I filed memo of retirement in this case, my lords. Kindly my acknowledgement.
Serial number?
81.
81.
Your Lordship, I'm appearing for R2, Your Lordship, appointed by the
Learned
High Court.
counsel
Legal
so and
Service.
so submits that he has entered appearance for the second respondent in place of Priyanka GM. Registry to delete the name of Priyanka GM and print the name of
Ashwin Joyston Kutina. Your Lordship.
so and so. Interim order ಇದೆಯಾ sir?
ಇಲ್ಲ entry model.
Your Lordship, in this case, the charge sheet has been filed, Your Lordship. The petition is rendered infructuous.
Challenge ಮಾಡಿ
Please, please,
madam. Is it charge sheet order? Yes.
please. apply.
Interim order ಏನಿಲ್ವಾ?
ಇಲ್ಲ, ಇಲ್ಲ.
Yes.
Hearing on IF?
You're getting stay. Yes.
I appear for respondent number 2, de facto complaint.
Huh?
I appear for respondent number 2, de facto complaint.
Yes, sir.
My lords, I had filed an application for vacating of interim order.
Hmm.
My lords, in this case, my lords, the petitioner is a borrower. I am the bank, my lords, the petitioner is a borrower. My lord, the petitioner avails loan by mortgaging the scheduled property, my lords, and avails loan of 37 lakhs. And my lords, initially the EMIs will be paid, my lords. Whereas after later then, the EMIs will be not be paid. During investigation, my lords, we found out, my lords, that A, 4 and 5, being the mediators, gets the petitioner to the bank, avails the loan, executes an agreement of sale from one called Sheila Felix. The Sheila Felix itself, the lady who is Sheila Felix is an earlier owner, my lords. She is not present right now. She is dead, my lords. Whereas, my lords, the accused number 4 and 5, in collusion with petitioner, creates a lady called Sheila Felix, impersonates the Sheila Felix documents, forges the documents, creates an agreement of sale and executes a sale deed, my lords, and avails loan. Later, my lords, we come to know, my lords, that the scheduled property has been earlier mortgaged by Arunachala and Iftikhar to many other banks, and the scheduled property is under SARFAESI Act. And my lords, if you see the petition, my lords, the account statement has been produced by the petitioner himself. There, my lords, we can see that from accused number 4 account, every month, 40 to 50,000, that is the EMI amount, has been transferred from Arunachala to petitioner's account. And petitioner pays the EMI to the bank. My lords, if the proceedings is stayed, my lords, let the proceedings go on, my lords. Let the investigation continue. That is the only submission, my lords.
I have one submission in this.
Hmm.
Property has been bought by the petitioners. ಅವನೇ ಹೌಸಿಂಗ್ ಅವ್ನು ಮನೆ ತಗೊಳ್ಳೋದಕ್ಕೆ ಅಂತ ಹೋಗಿ ಒಂದು ಮನೆ ತಗೊಳ್ತು ಅಂತಂದ್ರೆ ಬಿಲ್ಡಿಂಗ್ ನೇಮೇ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಬಿಲ್ಡಿಂಗ್ ನೇಮೇ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ಟು
ಯಾವ್ದ್ರದ್ದು?
ನಾವು ತಗೊಳ್ಳೋ ಮನೆದು
ಅಪಾರ್ಟ್ಮೆಂಟ್.
ಪಿಟಿಷನರ್ ಅಂದ್ರೆ ಬೋನಫೈಡ್ ಪರ್ಚೇಸರ್ ಆಫ್ ಎ ಪ್ರಾಪರ್ಟಿ. ಇವ್ರು ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಬೃಂದಾವನ್ ಗಾರ್ಡನ್ಸ್ ಅಂತ ಇರೋದು, ಅದು ಜಿಯೋ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಅಂತ ಇತ್ತಂತೆ, ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದು ಆ ಬಿಲ್ಡಿಂಗ್ ನೇಮೇ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಪಿಟಿಷನರ್ ಹೋಗಿ ಬೋನಫೈಡ್ ಆಗಿ ಬಿಲ್ಡಿಂಗ್ ತಗೊಂಡಿದ್ದಾರೆ, ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕಟ್ಟಿದ್ದಾರೆ, ಲೋನ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರು ಡಿಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇಂಟ್, ಸೋ ಕಾಲ್ಡ್ ಡಿಫ್ಯಾಕ್ಟೋ ಕಂಪ್ಲೇಂಟ್ NBFC ಅದು ದೇ ಹ್ಯಾವ್ ಡನ್ ಇಂಟರ್ನಲ್ ಪ್ರೋಸೆಸ್. ಒಂದು ದೊಡ್ಡ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅದು. ಅದರಲ್ಲಿ ಕ್ರೆಡಿಟ್ ರಿಪೋರ್ಟಿಂಗು, ಆಮೇಲೆ ರಿಸ್ಕ್ ಅಸೆಸ್ಮೆಂಟು, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ರಿಪೋರ್ಟು, ಎಲ್ಲ ಥರ ರಿಪೋರ್ಟು ತಗೊಂಡಿದ್ದಾರೆ. ನಾವು ಐ ಹ್ಯಾವ್ ಬಿನ್ ಪೇಯಿಂಗ್ ದಿ EMI. ನನಗೆ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡಿದ್ದಾದ್ಮೇಲೆ ದಿ ಶಾಕ್ ಇಸ್ ದಟ್ ಪ್ರಾಪರ್ಟಿನೇ ಇಲ್ಲ ಅಂತಂದ್ರೆ ವೇರ್ ವಿಲ್ ಐ ಗೋ?
ಇದು ಆಕ್ಷನ್
ಆಕ್ಷನ್ ಅಲ್ಲ,
ಇಲ್ಲ.
ಜಸ್ಟ್ ಪರ್ಚೇಸ್ ಹ್ಯಾವ್ ಟೇಕನ್.
ಜಸ್ಟ್ ಪರ್ಚೇಸ್ ಯಾವ ತರ ಮಾಡಿದ್ರಿ ಬ್ಯಾಂಕ್?
ನನಗೆ ಬಂತು ಮನೆ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು, ತೋದ್ವಿ, ನೋಡಿದ್ವಿ, ಚೆನ್ನಾಗಿದೆ
ಅಲ್ಲ,
ಅಂತ.
ನಾಟ್ ಥ್ರೂ ದ ಬ್ಯಾಂಕ್.
Not through the bank. And when I'm purchasing the property and I'm paying the EMI, EMI ನೂ ಹೋಯ್ತು, ಮನೆನೂ ಹೋಯ್ತು,
ಕೇಸು ಹೋಯ್ತು.
ಕೇಸ್ ಬಂದ್ಬಿಟ್ಟು ನಾನು ಅಕ್ಯೂಸ್ ಮಾಡಿ ನೀವು ತಗೊಳ್ಳಿ, ನೀವು ಅಂತಂದ್ರೆ ಏನ್ ಬರುತ್ತೆ ಅದರಲ್ಲಿ?
ಈಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಕೇಸು ಹೋಯ್ತು. ಎಸ್, ಏನ್ ಮಾಡೋಣ?
ಒಂದು ಅವ್ರದ್ದು ಒಂದು ಇದು ಕೊಡ್ಲಿಕ್ಕೆ ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ರಿಪೋರ್ಟ್, ರಿಸ್ಕ್
ಹಾ.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಅಂತ ಅವ್ರದ್ದು ಇಂಟರ್ನಲ್ ಒಂದು ಇದಿರುತ್ತೆ,
ಏನಿರುತ್ತೆ?
ಒಂದು ಪ್ರೋಸೆಸ್ ಇರುತ್ತೆ.
ಪ್ರೋಸೆಸ್ ಇದಿರುತ್ತೆ ಅಂದ್ರೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಕೊಡಿ.
Let them produce it on record
ಹ್ಮ್.
and then accordingly, ಯಾಕಂದ್ರೆ ಅವ್ರಲ್ಲಿ ಎಂಟೈರ್ ಅವ್ರು ಹೇಳಿರೋ ಲೀಗಲ್, ಅವ್ರು ಹೇಳಿರೋ ವ್ಯಾಲ್ಯೂಯೇಷನ್ಸ್ ಎಲ್ಲ ಅವ್ರು ತಗೊಂಡಿರೋದನ್ನ.
So you are the purchaser of the property.
I am the purchaser of the property.
They are benefited.
Where is the, I am the loser here. I am ready to be the witness.
Kindly.
ಈಗ ಅವ್ರು EMI ಕಟ್ತಾ ಇದಾರಲ್ಲ,
ಕರ್ತಿಲ್ಲ.
ಓ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದ?
ಹೌದು.
ಪ್ರಾಬ್ಲಮ್ ಆದ್ಮೇಲೆ EMI ಕಟ್ತಿಲ್ಲ,
ಅಲ್ಲ,
ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ,
ಬ್ಯಾಂಕ್
ಲೋನ್ ಕೊಡಬೇಕು ಅಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಇತ್ತು ಅಂದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಬೋದು.
ಮತ್ತೆ
ಬಿಲ್ಡಿಂಗೇ ಇಲ್ಲ.
ನೀವೆಲ್ಲಿದ್ದೀರಾ?
in the petition they say that we have leased the property. Let them give a document. Lease ಮಾಡಿರೋದಕ್ಕೆ ಯಾರು ಇದ್ದಾರೆ ಅನ್ನೋದು. Let them give the document.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಕೊಡಿ.
It is under investigation. I'll check it.
ಒಂದು ವರ್ಷ ಆಗಿದೆ. ಏನು ವಾಟ್ ಎವರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ has taken place, get it. Yes, heard the learned counsel appearing for the petitioner and the respondent. The learned HCGP is directed to place on record complete papers of investigation that has taken place till the date of the grant of the interim order. As interim order is granted on 31/10/2023 and the crime is registered long before the said date. List the matter on 26th, but 26th, yes.
Grateful.
Interim order subsisting shall continue till the next date of hearing. Why is the learned ASG waiting? Let me see. Yes, continue.
55.
ಏನ್ ಸಮಿತ್ ಸೇಮ್?
Probable man.
ಅಲ್ಲ, ಮನೀಶ್ ಕುಮಾರ್ ಎಲ್ಲೋ ಇದ್ರಲ್ಲ ಇಲ್ಲೇ.
I have served him a copy
Huh?
today, my lords. This is coming up for the first time.
Sorry, 83 ಅಂತೆ, ಒಂದ್ ನಿಮಿಷ.
I apologize.
MB ವೇದಾಚಲ.
I fear for the respondent too, my lord. ಸ್ಟೇ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀನಿ.
ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ ಯಾರು? 26ಕ್ಕೆ ತಗೊಳ್ಳೋಣ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
ಎಂಕ್ವೈರಿ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ
ಯಾರ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ?
ಇಬ್ರು ಫಸ್ಟ್ ಪಿಟಿಷನರು ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು.
ಇದು ಅಫೆನ್ಸ್ 504, 376, 506
ಓ, ಇದು 376.
ಹೌದು my lord.
ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ.
ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿ 4 ವರ್ಷದಿಂದ ಪ್ರೀತಿ ಮಾಡಿ ಅದು ಅವ್ರ ಮೇಲೆ
ಪೆಟಿಷನರ್ ಪೊಲೀಸ್ ಮನ್ನ.
ಹೌದು ಸ್ವಾಮಿ. ಪಿಟಿಷನರ್ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಕೂಡ ಪೊಲೀಸ್ ಇದ್ದಾರೆ.
ಪೊಲೀಸ್ ವರ್ಸಸ್ ಪೊಲೀಸ್.
ಬರ್ತಾ ಇದೆ. ಮ್ಯಾಟ್ರಸ್ ಮುಂದೆ ಬರ್ತಾ ಇದೆ. ಪೊಲೀಸ್ ವರ್ಸಸ್.
ಅದೇ ಬರೀ ಪೊಲೀಸ್ನವ್ರದ್ದು ಆಯ್ತಲ್ಲ.
ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ಭರವಸೆ.
ಎಸ್ ಸರ್.
The allegation is 376 and 420. That the promise of marriage. Lord, is a long back in the year before, prior to the filing of the complaint is 5 years earlier. And also my
5 years relationship.
5 ವರ್ಷ relationship is complaint is ward by law of limitation.
Ward by law?
Sorry, delay in filing the private complaint.
ಯಾಕೆ?
Lord, kindly see the,
ಕಾರಣ?
kindly see the complaint, my lord. Page number 20. ಈ ಮೂಲಕ ದಿವ್ಯಾ ಆದ ನಾನು ದೂರು ನೀಡುವುದೇನೆಂದರೆ 4 ವರ್ಷದಿಂದ ನಾನು ಪ್ರೀತಿ ಮಾಡಿ ತಿಂಗಳಿಗೆ
ಅದಕ್ಕೆ 4 ವರ್ಷ ಮುಂಚೆನೆ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತ?
ಅಲ್ಲ 1.5 year ಲಾಸ್ಟ್ ಅರ್ಲಿಯರ್ 1/8/2020.
ಲಾಸ್ಟ್ ಇನ್ಸಿಡೆಂಟ್ ಯಾವತ್ತು?
ಲಾಸ್ಟ್ ಇನ್ಸಿಡೆಂಟ್ 1.5 year ಬಿಫೋರ್.
ಇಲ್ಲ ಮೇಲಡ
1.5 year.
ವೇಟ್.
ಬಲವಂತವಾಗಿ ಇದೇ ರೀತಿ ನನ್ನನ್ನು ಲೈಂಗಿಕ 1.5 ವರ್ಷದಿಂದ ಬಳಸಿಕೊಂಡಿದ್ದು.
ಆಯ್ತು, ಆಮೇಲೆ?
And also my lordship has reported judgment.
ಅಯ್ಯೋ, ಅದು ತುಂಬಾ ಇದೆ, ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
My lordship is also referred in the Supreme Court reported judgment by Lord Pramod
ಅದು ತುಂಬಾ ಇದೆ.
Surya Bhavan Pawar.
ಎಸ್ ಸರ್. ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ಫಸ್ಟ್. ಹೂ ಆರ್ ಯು?
Lord, I am the,
ಯು ಆರ್ ದಿ ಪೆಟಿಷನರ್ ಅನ್ಬೇಡಿ. ಹೂ ಆರ್ ಯು?
Lord, in this service, I am serving in the police department. He is in working as a Chandrayapatna.
ಸರ್ವಿಂಗ್
He
ದಿ
is
ಪೊಲೀಸ್
working-
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇನ್ ವಾಟ್ ಕೆಪಾಸಿಟೀಸ್?
The police constable.
ಹಂಗೆ ಹೇಳಿ. ಸರ್ವಿಂಗ್ ದಿ ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಡಿಜಿ ಅಂಡ್ ಐಜಿ ವರೆಗೂ ಅದೇನೆ.
Sorry, police
ಎಸ್.
constable. Complaint is Lord John, that on 11/9/2023, the incident has happened on 1.5 year prior to the filing of the complaint.
ಹೂ ಇಸ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್?
But the complainant is the,
ಹಾ,
how to, 5 years is the living together relationship between love relation.
ಲವ್.
It to the petitioner number 1 and complainant. They permitted to read the complaint.
ಪೇಜ್ 22.
Page 20. 22 is a typed copy. 20 is a
20 is handwritten, sir. Who will understand that?
Please.
Yes.
22 minutes. ಈ ಮೂಲಕ ದಿವ್ಯಾದ ನಾನು ದೂರು ನೀಡುವುದೆಂದರೆ
3823 is the last incident.
Please.
Yes, sir.
my lord, ಇದು ಲಾಸ್ಟ್ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಬಂದು 10/8/2023. Kindly see statement of objection, my lord. Annexure A R1.
ಈಗ you are married to someone else, is it?
accused number 8 minutes.
ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿದಾರ ಇಲ್ಲಿ?
ಹೌದು, ಅವರು ಪಾರ್ಟಿ ಮಾಡಿ. ಪುಷ್ಪಲತಾ.
ಅವರು ಅಕ್ಯೂಸ್ಡ್?
Yes.
Why, sir?
Petitioner number 7.
You have all the acts to grind against him. Why all others in the accused?
All the father and mother and also the relations is also part.
ಅವರೆಲ್ಲ ಮೇಲಾಡಿದು ಮದ್ವೆ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿದಾಗ ಇವರು ಕೇಳಿದಾರೆ ಅವ್ರ ಮನೆ.
ಹೌದು, ಕರೆಕ್ಟ್. ಅವ್ರು ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ.
ಗಲಾಟೆ ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ ವಿಷ ಕುಡ್ದು ಅಲ್ಲೇ ವಿಷ ಕುಡ್ದು ತಲೆ ಸುತ್ತ ಬಿದ್ದೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಯಾರು?
ಇವ್ರು ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್.
ಸರಿ.
ಅದಾದ್ಮೇಲೆ ಅವರು ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಬಿಟ್ಬಿಟ್ಟು ಅವ್ರನ್ನ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಳ್ದೇನೆ ಮಾರನೇ ದಿವಸನೇ ಬಿಟ್ಬಿಟ್ಟು ಒಬ್ಬರನ್ನೇ ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದೊಂದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. ಮತ್ತೆ ಇದರಲ್ಲಿ ಮೇಲೆ ಇವ್ರು ಮದುವೆ ಆಗಿರೋದು 9 August 2023. ಅದ್ರ ಮಾರನೇ ದಿವಸನೇ ಇವ್ರ ಹತ್ರ ಬೆಂಗಳೂರಲ್ಲಿ ಬಂದು ಲಾಡ್ಜಲ್ಲಿ ದೈಹಿಕ ಸಂಪರ್ಕ ಬೆಳೆಸಿದ್ದಾರೆ ಮೇಲಾಡ್.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
ಮೇಲಾಡ್ ಮತ್ತೆ ಇವಾಗ ಮತ್ತೆ ಫೋನ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಟಾರ್ಚರ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ಮತ್ತೆ ಫೋನ್ ಮಾಡಿ ಟಾರ್ಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ?
ಹೌದು ಮೇಲಾಡ್.
ಇವ್ರ?
ಎಸ್ ಮೇಲಾಡ್.
I am not. ಹಾಗೆಲ್ಲ ಕಾಲ್ ಮಾಡಿ. ಮೇಲಾಡ್ earlier
giving torture or taking?
I don't know. First time we make it.
Yes. List on.
ಮತ್ತೆ ಇದು ಇವ್ರದ್ದು ನ್ಯೂಡ್ ವಿಡಿಯೋಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಇಟ್ಕೊಂಡು ರಿಟರ್ನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಮೇಲಾಡ್. ನೀನ್ ಬೇರೆ ಮದುವೆ ಆಗಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅವ್ರ ಮದುವೆ ಆದ್ಮೇಲೆ ನೀವು ಮದುವೆ ಆಗಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
ಮದುವೆ ಆಗಂಗಿಲ್ಲ.
I don't know. It was only for allegation.
ಇಲ್ಲ ಮೇಲಾಡ್, ಅದು ನ್ಯೂಡ್ ವಿಡಿಯೋಸ್ ಎಲ್ಲ ಇದೆ ಮೇಲಾಡ್.
ಈ ಅಲಿಗೇಷನ್ ಎಲ್ಲ ಇದ್ರೆ ವಿಲ್ ಸೆಂಡ್ ಇಟ್ ಫಾರ್ ಟ್ರಯಲ್.
Page number 32.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆ ಮೇಲಾಡ್. ಅದು
Let herself is filed an affidavit during the bail proceedings.
ಮೇಲಾಡ್ ಅದು ಇವ್ರ ಮೇಲೆ ಮತ್ತೆ
ಅಲ್ಲ ಅಂತ ಹೇಳಿ ಫೈಲ್ an affidavit. Is herself is filed.
ಮೇಲಾಡ್ ಅದು ಥ್ರೆಟನ್ ಮಾಡಿ
Just on 24th at 4 PM for dictating orders. Next.
54.
For stay?
17 years, 11 months.
Huh?
It's a proposed.
Settlement, 16th.
Well, in this case, victim is present, my lord.
So what?
Now she is 4 months pregnant. She cannot.
Don't get her. I have told you, why do you get the victim unless I tell you?
Please,
On 16th, I will take and tell you what is to be done, then we'll do that.
please.
Entry matter be kindly mixed.
Entry matter ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. Entry matter subsisting shall continue till the next date of hearing.
Problem.
Same 85 Monish Kumar serve ಮಾಡಿ.
I've served.
ಅದು ಯಾವತ್ತು ಹಾಕ್ದೆ?
16.
16th Hakiri.
16.
Yes.
Great.
Next. Vacating stay.
Lords, may kindly pass over minutes.
Passover. Passover 4 ಗಂಟೆಲಿ. What is this?
It's been-
This party in person, you should not do that. ಒಂದು ಅರ್ಧ ಗಂಟೆ ನೋಡುವ ಇರಿ. Yes.
Party in person, overflow was that.
Wait, sir. Wait.
It's proxy counsel appearing for the petitioner, my lords.
Huh?
I have proxy counsel appearing for the petitioner, my lords. The CC certified copies have to be produced.
What CC?
The certified copy of the interim order, the maintenance order that's being challenged, my lords.
Oh, this 45,000 case.
Please, my lords.
Your
On
proxy
13th
counsel.
13th
List
of
on,
June, they have
list
withdrawn
on Monday in the fresh matters list.
interim order.
Interim order subsisting shall continue till the next date. of
Copy not served, my lord. Them direct.
Tell your counsel to serve the copy. Yes.
Lords, and one submission, lords, seal number 67, the interim order was not extended.
Extend that. Yes. Take that 4 PM matter. 2:30 ಇದೆ. 3:30 ಅಂತ ಹೇಳಿದ್ರು ನಾನು. ಅಲ್ಲ ಅದೇ ನಾವು ಅದಕ್ಕೆ ತಗೊಂಬಿಡಿ. ಇದರ ನೋಡಿ 4:15 ಅಂತ ಹೇಳಿದೆ ಅವ್ರಿಗೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಇವರು 4 PM ಯಾವ್ದು?
88.
ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಟೈಮ್ ಮಾಡ್ಲಿ ಸರ್.
Someday.
We'll see. We'll give dates at the end.
143, further hearing 3:30 PM.
For the petition, this matter, my lord.
140?
Three lots.
Yes, sir, filing the compilation along with the synopsis, my lord.
ಏನಿದು connected matters?
Lords, these are the FIRs registered by the persons of the same group, my lords. This is that chief minister's letterhead was forged.
Oh, yes, yes.
Please.
Huh.
My lord, learned senior counsel the other day, my lord, pointed out as to how in the first matter, my lord, in 11,335 of 2023, the issue arises out of rupees 1.8 CR being given to the petitioner herein in order to close the matters pertaining to GST, my lord. What happens in this case, my lord, a brief background is that the petitioner has data which is confidential and has the names of several reputed institutions as well as builders against whom GST dues are pending. In the interim, my lord, the petitioner goes and touches base with certain high profile with high net worth individuals and solicits to close GST dues arising out of the last 7 years, or whatever dues were pending before GST. He says, I will undertake to close with them. At the said instance, one of the accused in the case is a GST commissioner. During the period when the money transaction has taken place between the parties, he is the GST commissioner of Bangalore. There is an apprehension, my lord, that the confidential data list has been shared through the GST commissioner. Through the course of which, my lord, the GST commissioner gets transferred to Gujarat. In pursuance of settling the matter, the petitioner undertakes a journey to Gujarat along with the complainant as well as other individuals and asks for X amount of money to be paid to these people, saying he will get the GST dues closed. That is one of the cases, my lord. In the second case, which is against one Miss Veena Narayan, which they say is the leader of the entire organization, which is filing false and frivolous cases against them.
No, each case is by the same accused and the same complainant?
No, my lord. The accused is common in all the cases.
Accused is common in
The
all.
accused is common in all the cases.
Complainants are different.
Complainants are different and are filed at different stages as well. They are not arising during the same.
File synopsis in each
Sir,
case.
filing synopsis.
ಎಲ್ಲಾದ್ರೂ ಹಾಕಿದ್ದೀರಾ?
I'm filing it right now.
ಹಾಕಿ ಮತ್ತೆ ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಡಿ.
Yes, I'm serving it.
ಕೊಟ್ಬಿಟ್ಟು
The facts are being presented in distorted
No,
way.
first file everything,
Please,
sir. You also, if you want to file something, you
I
file.
will file.
List the matter on 2nd August for further hearing. The parties to the list shall file a brief synopsis of the dates
I'm
and
filing my
events
synopsis.
by the next date.
There is one submission in the
I'll
series
raise
of
the
matters,
laptop.
my lords, last two matters in the series of matter. I am not appearing for the respondent. The respondent is the state in that case.
Only the
alleg-
state, is it?
No, in the last two matters, the respondent is the state. The allegation where he has fabricated the chief minister and the governor's letter.
That's all right.
It
That
the
is the
sec-
same content which is raising.
Wherever you are appearing, you file.
In the fifth matter, my lord, my name may be reflected as appearing for R2.
The the registry to print the name of Pratik Chandramouli. ನಿಮ್ಮ ಹೆಸರು?
Rajat, my lord.
Rajat, sorry.
Please.
ಬೇರೆದ್ರಲ್ಲ ಅವರಿದೆ?
The first matter I am appearing, the other connected matters.
Registry to print the name of Rajat A.
Please, only Rajat.
Rajat appearing for the respondent, second respondent in 143.4. ಇಲ್ಲ.
The 5-6.
5-6
only
ಇಲ್ಲ,
four.
4 ಮಾತ್ರ.
Please. Avinash is the petitioner.
Yes, 4 ಮಾತ್ರ. List on 2nd August.
The learned, my lord, the HCGP was directed to produce the investigation papers in that case. In all the
Produce,
cases.
my lord.
The learned HCGP is directed to secure the investigation papers and place it before the court on the next date of hearing. Yes. It's 4 PM. ASG ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದಾರೆ?
4 PM list, my lords.
140?
6 and 147.
No, which?
I'll just wait.
ಅಲ್ಲ, ASG ಯಾವ್ದಕ್ಕೆ? Yes, sir.
Lordship, we are appearing
ASG
in-
ತಗೊಳ್ಳಿ.
147.
Has your lordship taken up this
147.
Srimati Chandra Prabha and others?
No, sir, not that, sir.
Acha.
Yes.
Petitioner, please. This is a matter that my lords had heard briefly.
ಅಲ್ಲ, ನಿಮ್ reply ಕಾಯ್ತಾ ಇರೋದು. I've heard it 10 times.
Lord, would your lordships kindly take up the relief sought?
Because DSGI went on taking time on the ground,
ಇಲ್ಲ.
ASGI will come.
No, kindly turn to page 62 of
Padi.
the writ petition. Page 62, ink page 62, the printed page is 51. That's the
Yes.
relief. A is issue a writ of mandamus directing the respondent 1 to 5
To complete the formation.
of the road. ಅದಾಗಿದೆ, ರಸ್ತೆ ಆಗಿದೆ.
ಆಯ್ತು.
That is done. Lord, B is also related. I mean, it says to give assistance.
Hmm.
Lord, please have a look at C. Lord, C is a challenge to the notice issued under the Public Premises Eviction Act,
Hmm.
which is produced as Annexure A.
Hmm.
The ground of challenge is not the ground of issuance of the show cause notice, is that it is a defense land. Section 4 requires the estate officer to disclose the grounds. He says the land in your occupation belongs to the Defense Department. Defense Department is the absolute owner in possession. You have illegally
There
occupied.
is some survey conducted which says.
No, all that I'm saying is, Lord, can this court verify all those facts?
You have done yourself, sir.
No, now that I've issued a notice, my lord, let them give a reply. My lord, there is a date fixed. My lord, we'll refix the date. Let them produce the document. Let the estate officer take a decision. My lord, if they persuade the officer, my lord, all that I'm saying is in a writ jurisdiction, my lord, your lordship should not be called upon to examine as to who has the right title. My lord, that is in the domain of the estate officer. So
Yes.
let the petitioners appear before him. There is a date fixed.
ಅಷ್ಟೇ submission.
On the challenge to the show cause notice, that is my submission. The first two prayers, my lord, anyway, do not survive.
First two prayers, all right.
On the show cause notice, my lord, the ground on which it is challenged is that the petitioners claim that they are the owners. Now, who has to decide who is the owner?
The survey is conducted pursuant to the order of this court. Conducted pursuant to the order of this court, survey clearly shows they are the owner. In fact, you are in encroachment of their land ಅಂತ ಹೇಳಿದ್ದಾರೆ. That I will not accept.
Not my land, my lord, some other portion.
Whatever, but that I will not accept. You remain with whatever you are. Leave them wherever they are.
Please.
Because survey, I would have remitted it back. Survey is conducted pursuant to an order of this court. And that is placed before this court. That's the whole problem. Now you can't disown your own officer's survey or officer's survey. In the presence of your officer, survey is conducted. You can't disown that now. That's all. I'm not going to disturb any defense land here. Whatever their land is.
No,
That is what I told the DSGI also.
Let the survey be placed before the estate officer.
Why? It is pursuant to an order of this court and it is very clear to be placed here. Why again go to the estate officer, he rejecting it, another writ petition?
Defense or defense estate or the defense does not know that.
The, my lord, the protection of the
He has
defense
taken all
lands.
defense possible.
The, my lord, the protection of the defense lands is.
So I am
given-
not going to say anything
no.
about that.
The protection of the defense land
The
is given.
allegation is they are in encroachment of defense land.
True.
The survey conducted in your presence is clear that they are not in encroachment, but in fact, somebody else's land is in.
That's the point that I was trying to make. Not the protection of the defense lands is given to a separate entity called DEO, Defense Estate Officer.
Yes, no problem.
They are the ones, my lord, who have maintain the records. They did not have the benefit of
No,
participating in this.
He present in the survey, an officer of the defense, DEO itself
Avurilla.
was present.
Our Manila.
The
defense was there.
Yes.
Affidavit, my lords,
See the
filed by the
affidavits.
advocate,
Pudi.
by the
Affidavit
AG.
Pudi, affidavit
Dated
Pudi.
29/8/2023, enclosed.
No, I have heard this at length for on 3 or 4 occasions.
Sir, you ಕೊಟ್ಟಿಲ್ಲ. EO court ಕೊಡ್ತಾರೆ, copy to EO court. EO court is not.
It has been served on the estate officer. My lord, he is not the right officer.
It's not-
It is
we'll
the
see.
defense estate officer who should be present at the survey.
We'll say, all right, we'll answer that. Ashana, anything else?
ಅಲ್ಲ ಬೇರೆದೇನಿದೆ ಅಥವಾ
Fresh survey. In presence of all.
ಅಲ್ಲ Lord, my submission is not if the estate officer, my lord,
Well,
does
I'll
not have
answer
the
it.
ways.
If it is needed, we will send it back.
ಅಲ್ಲ, if there is a survey conducted in the presence of the defense estate officer, my lord, that would be meaningful, that would bind the parties. My lord, notice is given only to the EO.
Affidavit is filed by whom?
The government minutes,
State government.
please.
He does not.
State government is.
No, first survey was done. That was disputed. Then
No.
this court directed
If
in
you
the
are-
presence
if
of the
you-
estate
if you are-
officer, state government shall conduct a survey.
If you are, my lord,
Survey is conducted, that is by an affidavit that is placed before this court. That is all I am required
my
to
lord,
answer.
my lord, was the survey conducted in the presence of the appropriate authority who is invested with the power to protect the defense lands?
We'll see.
No, that was not done. So I thought I'll pursue your lordship to have one final survey done in the presence of the defense estate officer so that all issues can be resolved.
We'll answer it.
Lordship may consider that.
My lords, may I just make one submission in response? On 11/7, when the order was passed by this honorable court, it was heard extensively, where one of the submissions was, if it is a disputed question, then the estate officer, the defense estate officer loses jurisdiction. In fact, those case laws are placed before my lords also. So
Heard
referring it
reserved.
back, my lords, would be without
We'll see,
jurisdiction.
yes,
ma'am.
yes. Heard reserved. Idu, long back, I think on 5 or 6 occasions I have heard and he
Long
had
legacy.
submitted. Yes, sir. The AG also remembers still, see.
After a long time back, because your lordship had directed the state government
Yes, yes.
as to the survey department.
Yes, sir. In GM, that was. Yes, now why are you waiting?
145.
ಯಾವ್ದದು?
140, 146, next matter.
Oh, this, what did you do?
My lords, we have written, the BBMP has written a letter to the state government to release 100% of the funds, my lord.
Hold sir,
So your lordship may have it after 2 weeks. 75% is being paid.
hold sir idrala. Sir,
The communication is here. my
I saw you there, but it don't. 100% ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
We have written, the BBMP has written a communication to the state government, my lords. This internal communication between the state is not for thing, my lords. Once that is done, my lords, insofar as of now, 75% is first 50, then 75.
75 ಆವಾಗ್ಲೇನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
That's a now we are,
ಇಲ್ಲ, ಇನ್ನ ಮಿಕ್ಕಿ 25 ಕೊಡ್ತೀವಿ ಅಂತ.
the balance.
ಪೂರ್ತಿ 100% ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. If that is there, then fine.
Therefore, your lordship may kindly grant have it after 2 weeks.
I'll take it on 24th. That should be fine. Tell it,
31st,
ಬೇಡ.
31st,
No, take it on 8th August.
please.
8th August, anyway, protection order is there.
ಅಲ್ಲ ಪ್ರೊಟೆಕ್ಷನ್ ಇದೆ. ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಇನ್ನು 8th August ಅಂದ್ರೆ ಈಗ 1 ತಿಂಗಳಾಯ್ತು ಆಮೇಲೆ.
No,
ಇಲ್ಲ, ಇದು further hearing.
75% is being,
No, anyway, this is part heard. 8th. The learned advocate general would submit that the instructions are issued to the concerned to release all the amount that is to be paid.
lordship can put it this way, if I may request, my lord. The BBMP has requested the state government to release 100% of.
The learned advocate general places on record a communication which directs the BBM,
Request the-
which requests the state government to release. BBMP to state or what?
PBMP to state government.
From hands of the BBMP to the state government to release the entire amount that is due to the petitioner, due to these petitioners,
Decision is pending at the state.
due to these petitioners, apart from what is already paid.
The only thing is that the ಸರ್ಕಾರದ ಆದೇಶಕ್ಕೆ ಕೋರಿದೆ.
That's what.
ಯಾವ ಪರಿಸ್ಥಿತಿ?
ಮಾಡ್ತಾರೆ. The list on
You cannot direct the BBMP.
list on 6th August. Yes, in the fresh matters list. Close ಮಾಡ್ಬೇಡ. Yes. ಬೇಡ fresh ಬೇಡ. Further hearing ಇರ್ಲಿ.
ನಾವು undertake.
In the next matter, my lord.
ಯಾವ್ದು next?
46. my lord.
140?
147.
147. ನೀವಿದ್ದೀರಾ?
But I am appearing in
WP number
147.
17801, my lord.
17?
80. My lord, petition itself is not maintainable in that, my lord.
No, 1 minute.
But
Yes, sir.
I am appearing for
ಅದು
the
ಇದರಲ್ಲಿ
petitioner.
ಇವರದ್ರಲ್ಲಿ
Sir,
I am appearing for the petitioner.
one
But
minute.
this is
Prashant,
a-
sir, 1 minute, sir. 1 minute.
Yes, yes.
ಇವರದ್ರಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ರು ಅದು ಬೇಕಾ?
What undertaking?
146 ಅಲ್ಲಿ they had given an undertaking that they will not precipitate ಅಂತ ಹೇಳಿ ಅದು ಬೇಕಾ?
That will continue, sir.
Interim order passed earlier to
ಅಲ್ಲಿ,
continue.
okay. Interim order of any
ಅಲ್ಲ,
kind
ನಮ್ಮ
subsisting,
ಅಂಡರ್ಟೇಕಿಂಗ್ ನಾವು ಕೊಟ್ಟಿದ್ದು.
you will not precipitate ಅಂತ.
ನಾವು ಅಂಡರ್ಟೇಕಿಂಗ್
ಅದು
ಕೊಟ್ಟಿದ್ದು.
ಏನು ಕಂಟಿನ್ಯೂ ಮಾಡೋದು ಬೇಡ, ಹಂಗೆ ಇರಲಿ, ಕೊಡ್ತಾರೆ.
Let them.
All right.
6th August. ಅವರು ಏನು ಮಾಡಲ್ಲ ಬಿಡಿ.
ಆಯ್ತು.
Yes.
That's only vis-a-vis the contempt, I suppose.
Only the contempt.
Contempt.
But anyway, all is well that ends well. Leave it. Yes.
Leave.
Yes, sir.
It's only because the intervention is
But in 147, I appear for the petitioner.
Yes, sir.
47.
But this is a very serious petition seeking a SIT investigation.
Which one, sir?
Into
That is
147.
17801.
Yes, 1780. Into very serious allegations of cheating, criminal breach of trust, forgery, and bribery involving some judicial officers also.
Yes.
Now, in this case, Lord, we are seeking a SIT investigation, court-monitored SIT investigation, because of the nature of the people involved in this, which includes, Lord, the present Lokayukta of the state.
No, that's
includes some lawyers, that is his wife and his
no.
son.
Let's not go into the names, sir. You just
No,
make
I'm
a
not
submission.
going. I'm not going into any
Yes.
names, my lord. I'm
Yes.
just pointing out why we are seeking. Normally, my lord, we would have sought a registration of FIR on these allegations on the basis of Lalita Kumari's judgment.
Yes.
That should have been normally sufficient.
Yes.
But in this case, my lord, because of the nature of people involved in the allegations and the nature
Yes.
of the influence of the accused persons,
Yes.
just the police investigating this matter will not be adequate, will not be
Yes.
proper.
Yes.
It would have to be investigated by a SIT under the monitoring of this court because of the nature of the allegations and the nature of the evidence. In fact, my lord, we have annexed the transcript of conversations.
I've seen, yes.
Yes, my lord. Those transcripts show that there were talks about bribes being paid to some judicial officers. There were discussions about bribes being paid to some judicial officers. Now, these are very, very serious matters, which for the reputation of the judiciary itself, they need to be investigated thoroughly, and the court needs to get to the bottom of this. So therefore, a credible investigation in these kind of allegations is essential. And they involve, Lord, not just, there is also acquisition. Firstly, my lord, there is sale of properties on the basis of a forged, virtually a relinquishment deed or a forged memo, on the basis of which about 1,200 crores worth of properties were sold because of lack of injunction by this Prestige Group. There is also an allegation of the acquisition of properties worth hundreds of crores by the lawyers in question, during the pendency of this litigation, and we are alleging that the source of that funds must have been from the opposite party. So there are very, very serious allegations involving the very integrity of the judicial process, which need to be investigated. And the seriousness of the petition can be gauged from the fact that the petitioners have disclosed that they in fact paid a very substantial amount of money which these lawyers demanded, which they kind of scared the petitioners into believing that unless this money is paid, their case will get dismissed. Therefore, they were basically asking the petitioners to pay some money to be paid to some judicial officer. And thereafter, in this transcript, they say that the other party must have given some flats to the judicial officer, and they have got it from the horse's mouth, etc. So therefore, Lord, in my respectful submission, this is a matter which the court should take very seriously and get to the bottom of this. Find out what exactly has happened, because this involves the very integrity of the judiciary. It involves, in fact, the integrity of a very, very important institution under the Constitution, that is the Lokayuk. So therefore, my Lord, that's why I'm saying that this court needs to take this matter very seriously, needs to ask, needs to constitute an SIT to get to the bottom of this. Because we made a complaint to the police authorities, to the various respondents, etc., detailing all these allegations, annexing details of the property transactions, the sale deeds, etc. in question. But so far, not even an FIR has been registered.
When was the complaint given?
But it was given on the 14th of June this year.
Of this year.
Prior to this, 1 year back, we had written to the authorities, but that has not been.
Prior to that, also about a year ago, Lord, apparently the petitioners had written.
What are the dates of the complaint, sir?
The formal complaint, which is annexed to this petition, Lord, is of 14th June. That is at page 81.
14/6/2024 or 23, sir?
24.
24. The earlier complaint?
Annexure A.
Earlier complaint is Annexure A. That is, the date is page 49. Page 49 is dated
25/12/22.
Yes, 25/12/22.
It is to the Honorable Chief Justice.
That's to the Honorable Chief Justice.
Yes.
But the authorities were copied this complaint, the other police authorities. It was sent to the chairman of the Bar Council.
Anyway, that would not become a direct complaint.
Yes, that's
Anyway,
true. That's true, my lord. The direct complaint is of this
14/6/2024.
Yes, that's true.
Now
That's
you are
true.
seeking constitution of a special investigation team on the
Yes.
complaint dated 14/6/24.
Correct.
Yes.
Correct. We want that because that complaint contains very serious allegations.
We'll
And
hear
those
the-
allegations do not go to the very root of
Yes.
the judicial process.
Yes, sir, you have told that. We'll hear the Advocate General is here for this. We'll hear.
Yes.
Yes, sir.
The short question is whether this court can issue a mandamus, my lords. Yeah.
Mike.
Lordship may kindly see the prayer, my lords, which they have sought for. Your lordships will get it at page number, my lords, 46. Seeking mandamus directing FIR to be registered on a complaint dated 15/6/2024. Therefore, my lord, first of all, my lords, after giving the complaint, my lords, they filed this petition on 1st July. So first, my lord, Supreme Court has said, my lords, writ petitions filing mandamus should be deprecated, my lords.
Which one?
Your lordship may kindly see 2008 2 SCC 409, my lords. Para 27.
What's that?
I'll just read it out and I'll hand over, my lord.
You don't have a copy?
Oh, yeah. Para 27 and 28, my lords.
Sakrivas.
Please, my
Yes,
lords.
sir.
There's two other judgments, my lords. which says that
No, now first you, which paragraph in this?
27 and 28, my lord,
27?
and 28, my lord.
Uh,
As we have already observed, the magistrate has wide power to direct registration of affair and to ensure proper investigation, and for the purpose, he can monitor the investigation to ensure that the investigation is done properly. The High Court should discourage the practice of filing writ petition or petition under 482 simply because the person has grievance that his affair has not been registered by the police, or after being registered, proper investigation has not been done by the police. For this grievance, the remedy lies under section 36, 154(3) before the police officer concerned. And if that is of no avail, under section 156(3) of the CRPC before a magistrate, or filing a criminal petition under section 200 of the CRPC, and not by filing writ petition or a petition under section 482. It is true that alternative remedy is not an absolute bar to a writ petition, but is equally well settled. If there are an alternative remedy, the High Court should not enter. Your Lordship may kindly see, going by the complaint, the incident dates back to 2019, 20. The other representation goes to show that 2022. The way the petition is filed in July, 15th of July, and approaches within a period of 14 days to show that he has kept quiet. It has nothing to do with the judiciary or anything. It's a civil dispute which is pending, and they're trying to drag in other people. In fact, the Judicial Protection Act, Judges Protection Act, all that is there. So therefore, that is independent of this. Question again ultimately boils down to whether, in a given facts of circumstance in this case, where going by the complaint, I would just like to show the complaint, few paragraphs in the complaint, my lord. The Lordship may kindly turn to admitted facts, page 83, para 5A, my lords. Para 5A. This complaint arose of the above said civil suit of 4709 of 2019. That is the first basic fact where the complaint arises out of, my lords. Then can I request, my lords, page 85, 6A. In April 2019, so-and-so informed the complaint of potential additional expenses so-and-so and agreed fees, my lords. That is again dates back to 2019, my lords. Then, my lords, if your Lordship may kindly turn to page 88, my lords. The allegation at page 88, my lords, just above para B in the middle, in order to keep the complainant's confidence, response in further striking so-and-so advised the complaint in I number 33 before the trial court, seeking implement of family business entities, challenge the order dated 26/2019. After that, my lord, they go back and get the MFA filed in 2020. Then, my lords, 88 last paragraph, subsequently filing of the writ petition and dispose of the writ appeals. So therefore, my lords, what transpires is a case of civil dispute between few people. And in order to make what you say, my lord, I would say, my lords, I don't want to prejudge the issue with regard to whether it's malicious prosecution or they're going against anybody. We're having an alternative remedy, my lords.
Alternative remedy of?
For filing a complaint or whatever it is, my lords, in law. So, and in fact, if I remember from going to the petition copy, they already had approached this honorable court, my lords, to the by way of to the bar council, my lords, with regard to the.
That is the companion petition that is there.
Oh, I'm not.
There are two other petitions here. Yes.
Your lordships have directed them to go to the bar council, my lords, of India, because
that is not yet decided because
there is an order passed by this court. I'm given to understand, my lord, what is pending is only regarding deletion of certain paragraphs in the petition.
The order 6, rule 16.
Order rule 6 application, order 6, rule 16. So therefore, my lords, insofar as the main matter is concerned, my lords, with regard to the very same allegations, this court has already decided saying that the matter has to go to the Bar Council of India. That will be decided by the Bar Council of India. The short question is whether a mandamus can be issued at this stage to register a complaint. In fact, my lord, Lalit Kumar, all that, my lords, clearly say the inquiry has to be done prima facie. It has to
preliminary
be,
inquiry.
I mean, in the sense, looking into the allegations, my lord. Here, my lords, without exhausting filing an appeal, again affidavit, all the procedure contemplated therein, my lords, directly approaching.
No, it is complaint, there is no need of an affidavit. This is a private complaint.
No, it is just a,
It is a
just a
complaint.
complaint given by your lordship may kindly
The
see.
complaint to whom?
Commissioner of
To the
Police.
Commissioner.
So
To the
therefore,
Commissioner of Police.
please, my
No,
lords.
whether he would direct it to the jurisdictional police or not is a different thing. But what is being sought is constitution of an
Why does
SIT
it arise?
based upon the said complaint.
The question,
That we will answer. Yes.
my case is, my lords, a prayer of this nature to constitute an SIT does not arise at all. my lords.
We'll see. Anything else, sir, in reply?
On the alternative remedy.
Anything else in reply, sir?
Yes, Lord. I just wanted to respond to their first thing that the learned advocate for the state said, that we have an alternative remedy by way of approaching the magistrate, etc.
Yes.
That remedy is not there for an SIT. The magistrate has no jurisdiction or power to order an SIT. He can only at best.
No, he
order the
cannot order
registrar-
SIT, that is true. He
can
can
only
refer it for investigation to the police.
That's all that he can do. So that's not a remedy for this kind of case where we are seeking an SIT for good reasons because of the nature of the allegations and the nature of people involved in the allegations involved as the accused.
Yes.
And so he's saying that mandamus cannot be issued. Mandamus can certainly be issued if an SIT needs to be constituted. Your Lordship has recently given a judgment on this. The Supreme Court has given a series of judgments, starting with Vineet Narayan, then in the Colgate case, then in the 2G case. In so many cases, the court ordered SITs with court-monitored investigations. In that Gujarat riots case, also the court ordered an SIT which was court-monitored. So therefore, there are any number of precedents which I believe your Lordship has already discussed in the case of recent judgment of Manjula versus State of Karnataka.
Yes.
In a judgment of 2022.
No, that is where I handed over the investigation to CBI.
Yes, correct. So it is this court, only the High Court or the Supreme Court, which has the power to hand over the investigation to the CBI or to constitute an SIT, whatever is appropriate in this case. And I have said, my lord, my learned friend is saying that the dispute arose out of a civil suit. Yes, it arose out of a civil suit. But thereafter, during the course of that civil suit, several criminal acts have taken place, including forgery, criminal breach of trust, cheating, and thereafter, my lord, as the conversations disclose, apparent bribery of judicial officers. So therefore, that is why I am saying, because this case involves also somebody among the accused are people who are very influential, occupying very high positions in the apparatus. Therefore, my lord, it would be appropriate for this court to constitute an appropriate SIT and monitor the investigations by the court. And we have placed all the facts on the table in our complaint, including our role in the matter. Everything we have put on record, that this is the situation, this was the circumstances. We have placed on record the transcript of the conversation. My learned friend has a copy of the conversations there. He can hand over the pen drive to you, which your lordships can hear the conversations also. We have also pointed out that prima facie, we have got those conversations examined by forensic experts who have said that yes, this is the voice of these people. This lady lawyer, as well as her son, who is also a lawyer, who were our lawyers. So therefore, my lord, in these circumstances, it is my respectful submission that in this kind of a case, in this kind of a complaint, the appropriate thing would be for the court to monitor an investigation by an appropriate body. Your lordship can decide which would be that appropriate body. It could be the CBI. It could also be some handpicked officers, whether retired or sitting officers, but who command the confidence of the court, and the court should monitor it because this is a very sensitive matter. It involves the very integrity of the judiciary.
Yes, let's see.
That's my.
Two other judgments are there, my lords. I'll just place it.
Give the judgments if you
Just,
have it.
in fact, I'm sorry, I just came to know this time. One is XYZ was the state of Madhya Pradesh, my lord, to 2023 9 SEC 7
XYZ.
That there was the state of Madhya Pradesh. I'll just read the two paragraph, my lords. First, we find it appropriate 2023 9 SEC 705, my lords. First, we find it appropriate to reiterate the duty of the police to register FIR whenever a cognizable offence is made out in a complaint. Constitution bench of this court in Lalit Kumar is so and so has laid down the position of law as summarized in following extract, that is para 119. Therefore, in view of the various counter claims regarding registration and non-registration, what is necessary is only that the information given to the police must disclose the commission of a cognizable. In such a situation, register offencer is mandatory. However, if no cognizable offence is made out in the information given, then the FIR need not be registered immediately, and perhaps the police can conduct a sort of a preliminary verification or inquiry for the limited purpose of ascertaining as to whether a cognizable offence has been made. But if the information clearly mentioned the commission of a cognizable offence, there is no other option. So the other consideration. Then, my lord, insofar as your lordships are well aware of Priyanka Srivasta's case, even that also, my lord, para 29 and 31 reiterates this. I'll just take out that. My lord, first of all, SIT would arise only if it is a case for FIR is registered. After all the process, the question is too premature for an SIT to be constituted directly based on a complaint which is given 14 days back. The whole case, my lord, is ultimate. I'm sorry for repeating, my lord. It is a pure case of civil. It is a simple case of civil dispute, property dispute, which has been blown out of proportion because one of the persons happened to hold high office. That's the whole thing, man. The whole rest of it may not be relevant at all, man. So therefore, my lords, 2019 complaint dispute, and one other thing, my lords, it may be on merits of the matter. Going through the complaint itself, my lords, neither the memo or the order has been sought to be challenged. I've made grievance of by the complaint which requires an SIT investigation because that has become final. Neither the JDA going on the allegations in the claim, that has also not been challenged. That has become final. The grievance of the whole complaint is, my lord, that is agreed by certain facts. So therefore, my lords, being a purely civil, if you look at read the complaint as a whole, so therefore, my lord, it is not a case where SIT is required to be constituted in this given situation.
All right, we'll answer. Heard the learned senior counsel Prashant Bhushan appearing for the petitioner and the learned advocate general representing the state. List on 18th for dictating orders.
My lord, regarding the other two connected matters.
You are appearing in those two as well, sir?
No, Lord, Nisha Tiwari, my colleague, she will argue online. She's here with me. She is fully prepared in that matter.
No, I've heard her. We'll take it on another day. It's 4:45 now. There are other part-heard matters.
Very well.
On the same day, we'll take it, sir.
Very well.
My lord, 18th of?
On the 18th.
This month.
18th of this month.
Yes, yes.
My lords are fixing some time.
Sorry?
Are your lordships fixing any time for the matter, my lord?
No. I will take it on the 18th, yes.
My lords, I just want to apprise this honorable court that there is already in the connected matters, ex parte ad interim order is continuing for more than 75 days, my lord. This is one. The other thing is I have already filed an IAA seeking vacation of the order.
Yes, we will hear you on that only, madam.
My lord, just to apprise your lordship that these two things are pending, my lord.
Yes,
Keeping that.
I'll hear you on that, yes.
Okay.
Yes.
I'm grateful.
Yes. They have 145 on the madam. 144,
One request, my lord. Of course, if it takes some time, then it's fine. Otherwise, 18th, I have some personal inconvenience for that day.
Let's see. We'll adjourn.
ಮತ್ತದೇನಾದ್ರೂ ಇದ್ರೆ ಅವತ್ತು
ಅವತ್ತು ಹೇಳಿ.
I'm order, my lord, to be continued.
That will continue,
Please.
whatever
Great.
form it is. 144, only first man.
42.
Huh.
This is the offense, your lordships recollect.
Mike,
Your lordships recollect, my lord, this is the offense where I am appearing for the landowner. The complainant has purchased an apartment falling to the developer's share. Developer, my lord, is absconding. There are civil disputes between me and the developer, which is pending before this honorable court. He has also initiated a RERA complaint and got an order, my lord. Then he files a 420 case against the landowner.
Objection.
objection. Yes,
Yeah,
sir.
because the landlord, I mean, developer has not been absconding. He's one of the signatory in the new committee being formed by RERA. So how you can say he's
All
abscond?
right, you don't address him.
Yeah, sorry.
Yes.
So what I'm trying to say, page number 47 and 79, the landlord and the,
It's a date and time for you because it's 4:45 already
okay,
and a lot of advocates are waiting.
today is 10th.
When do you want?
Day after tomorrow,
Not so soon.
before 17th. I'm traveling after 18th, then 3rd August. It will be too late.
We'll fix it on 6th August then.
6th August.
Yes, 6th August at 3:30 PM.
Okay.
Order, my lord.
That will Ilva. Okay.
3rd August is also okay for me.
Because it was party in person.
3rd is not okay for the court.
4th,
Saturday. 4th is Sunday.
5th.
Every day will be okay. for
Okay,
you.
5th
Yes.
and 6th. Now
6th
which day?
August. Let's the matter on August the 6th, 2024.
3:30.
At 3:30 PM.
Okay.
Munchenu ಕೊಟ್ಟಿಲ್ಲ.
Thank you.
Lordships will direct.
Earlier bench also is not granted.
It's because
So
party
wait,
in person, so
nothing is going to happen. Charge sheet ಹಾಕಿದಾರಾ?
ಇಲ್ಲ.
Investigation ನಡೀತಾ ಇದೆಯಾ?
ನಡೀತಾ ಇದೆ.
Investigation papers ಕೊಡಿ.
I'll place it on.
Yes. Learned HCGP is directed to secure the investigation papers and place it before the court. Then don't take any coercive steps in the garb of investigation. Yes, that's
Great.
all. 6th.
Yes.
Okay, thank you.
142.
140? ಅದು further hearing. Orders 330. ಐದಿತ್ತಲ್ಲ ಮೇಡಮ್ ಅಸೋಸಿಯೇಷನ್ ಒಂದಿತ್ತಲ್ಲ ಯಾವ್ದದು? There are so many further hearing matters. One ನಿಮಿಷ. You call the further hearing matters from 135. Huh? Further hearing. ಇಲ್ಲ ಬೇಡ 3:30 PM ಅಷ್ಟೇ. There, I'll call all the further hearing matters. 1 minute.
35.
No problem.
Yes, sir.
135.
The petition is.
Recall ಮಾಡಿದ್ದೀನಲ್ಲ.
Recall ಮಾಡಿದ್ರ. So last time on 12th February, so Lordship was pleased to hear both the parties and reserve it for orders.
We'll do that only then.
Please,
ಅಷ್ಟೇ.
let the matter be posted for orders.
I'll post, not reserve it today.
Please,
I'll, the filed up reserve matters,
date
finish
will be
it. No, I'll post it on 19th,
please.
list on 19th,
Oblige.
136.
136.
ಬಾಲಕೃಷ್ಣ, ಅದು 19th ಹಾಕಿ ಮಾಡಿ, 19th ಅಲ್ಲ 26th ಹಾಕಿ. 137.
137.
Petitioner.
PG ರವಿ
Please, bar council.
ಇಲ್ಲೇ ಇದಾರಲ್ಲ. ಹೌದು, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಮ್ಯಾಟ್ರಾ? ಹಾ, ಏನ್ ಮಾಡಿದ್ರಿ?
So on the merits, the matter heard on the merits.
No settlement? ಏನು ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀವಿ ಅಂದ್ರೆ?
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಇದ್ಕೊಂಡು ಮತ್ತೆ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಹೋಗ್ತೀವಿ. ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್ ಇವೆಲ್ಲ.
When sir is there, it's not settled. I'm surprised. Why?
Because we have.
Well, on merits, sir, I'll hear it on merits, no problem.
Not more than 2 minutes, on merits.
2 minutes?
That's just.
What do you mean?
It's public exchequer money,
No, wait, he is the petitioner. Not more than 2 minutes. Now 2 minutes, sir? I'll probably take it on Tuesdays. Tuesday ತಗೊಂತೀನಿ. ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲಲ್ಲ. ಎಸ್ ಅಲ್ಲ, ಅವ್ರೇನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲೆಕ್ಷನ್ ಏನೇನೋ ಅಂದಿದ್ರು ಅದಕ್ಕೆ. ಏನಿಲ್ವಾ? ಎಲೆಕ್ಷನ್ ಆಗೋಯ್ತಾ?
It has been stayed by the Bar Council of India.
Stayed. ಮತ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲೆಕ್ಷನ್ ಇದೆ ಅಂದ್ರೆ
ಇಲ್ಲ ಪ್ರೋಸೆಸ್ ಆಗಿತ್ತು ಸರ್ ಅಲ್ಲಿ BCA ಇಂದ ಸ್ಟೇ ಆಗೋದು.
ಸರಿ. Then I'll take it on Tuesday.
Tuesday ಒಂದು ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಡೇ ಆಗ್ಬೋದಾ? Wednesday or
Wednesday is holidays.
then
17th.
Thursday ಆಗ್ಬೋದಾ?
Thursday ಹಾಕೋ.
Very
Yes.
great.
List on Thursday at 4 p.m.
Please.
Yes. At 4 p.m. time ಕೊಟ್ಟಿರ್ತೀನಿ.
Yes.
2 minutes. Yes. Interim order subsisting shall continue till the next date of hearing.
138. Appearing for the petitioners, Manoj.
See.
That's Thursday, 4 p.m.
Yes, 4 p.m. Thursday, 4 p.m. Yes.
Much obliged.
Next.
39. I appeal for the respondent bank in this case. For the respondent bank. There are 3 loans obtained by the respondent bank.
Petitioner ilwala.
Lord, I'm for
Need yaru?
respondent number 4, my lord.
Auction purchaser.
Purchaser.
Let it come before the regular bench. Yenidu?
That's Toyota Innova car case.
Oh, Innova car. Hagari ille irli. Yes.
So that was.
My lord, I'm for the auction.
You have purchased the Innova car.
Yes, my lord.
You'll have to give it back. They have played harakiri here.
Lord, I may be heard, my lord, before
You will be heard. Question of Innova, you will be heard. Yes. Petitioner Barley.
It may
The
be.
erstwhile owner of Innova is not here. Without notifying him, you have sold the car. What is this?
My lord, the earlier.
EMI due irlilla. Ilde iro EMI due alli he accepted. Vignesh Shetty accepted that yes, there has been a mistake, that they have sold the car.
My lord, my humble
Sold the car
submission is.
without notifying
No.
the owner.
It is a wrong thing, my lords. There is a communication gap between the Vignesh Shetty and bank. See, when bank has intimated him that it is not sold, the sale notice has been given to him, but it is not sold.
I have passed detailed orders.
Yes, I gone through it, my lord. That is the reason. And because of this, 2 other.
Collection of that order will be the writ petition order.
No, because of this, there are 3 more vehicles have been seized. And.
ತರ ಮಾಡಿದಿರ ಎಲ್ಲದರಲ್ಲೂ?
My lords.
ಇದೇ ತರ ಮಾಡಿದಿರ ಎಲ್ಲದರಲ್ಲೂ?
ಇಲ್ಲ, my lords. ಆ ತರ ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
ಆ ತರ ಮಾಡಿದಿರಲ್ಲ, ಅದಕ್ಕೆ ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
by law, my lords. ಅದಕ್ಕೆ if this court given an opportunity to petitioner.
Return the Innova?
No.
Then?
How can we return?
How can you return? Or the money or
No,
the
we are
Innova?
on the grounds of this one. We are, as per the surface provisions only, we have done everything.
You have done everything in accordance with law.
Yes, my lords. See, based on that only I can appear before this court. Otherwise, if anything.
Illegal ಆಗಿ ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ ಅಂತ.
Then I'll be.
Legal or illegal, you have to defend the action. That I will hold, whether it was illegal or legal.
If it is illegal, then I have no understanding.
It may be taken up in the next week, my lord.
ನೀವು ಅದನ್ನೇನ್ ಮಾಡಿಲ್ಲಲ್ಲ ಇನ್ನೋವನು? ರೀಸೇಲ್ ಏನ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ರಿಜಿಸ್ಟರ್ ಆಗಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಅವರು. ಅಲ್ಲಿ RTO ಗೆಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್
ಕರೆಕ್ಟ್
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಗಿದೆ.
My lord, the RTO documents have not yet been migrated to minor.
Very good.
ಹೆಸರಲ್ಲೇ ಇದೆ.
Very good. No problem. Yes.
My lords, I have good case on merits. Can you have it on Monday?
We
Then
have an excellent case on merits, we will take.
Yes.
My lord, there's one submission, my lord. I am in the cause list. I am being shown as advocate for respond number 5. There is actually no respond number 5, my lord. It may be correct.
Which respondent are you?
Respond number 4.
Registry to print the name of H.S. Purnima as appearing for the 4th respondent and delete the name of Vignesh Shetty as appearing for respondent 1 and 2. You are
I
representing.
filed NOC wakalat in this R1 and R2.
That is first mistake by the bank is that I have heard Vignesh Shetty completely and now they change the counsel.
ಇಲ್ಲ,
No
when
problem.
bank is approached him, ಇಲ್ಲ ಅವರು he is also my friend colleague. The thing is,
That's not the concern of the court whether you are friends or enemies.
No, I'm not.
But you can't change the counsel
No, when Vignesh
after detailed orders being passed.
My lords, there is a communication gap that which Vignesh Shetty also agreed for that.
That's all right. We'll see.
ನಾನು ಆ ತರ assume ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟೆ ಅಂತ he has confused before the bank.
Assumptions ಎಲ್ಲ we will ward off. No issues. Next time. There's no petitioner ಇಲ್ಲ.
Can I have it on Monday, my lord? Date may be given.
Where are you, sir?
My lord.
ಇನ್ನು 4:45 ಗೆಲ್ಲ ಮನೆಗೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ಲೇ?
Sorry, my lord, there was another matter.
List on 19th.
Please, man.
Yes. List on 19th at 4 p.m.
My lord, it's Friday. ಈ Friday, not Friday.
Yes, next.
Obliged, my lord.
ಆಯ್ತು ತಗೊಳ್ಳಿ. You 2:33 ಬಂದ್ಯಾ?
30 more matters. Number 1.
ಎಜ್ಜಿಗೆ ಇಲ್ಲಿಂದ ಮನೆಗೆ ಹೋಗು. Yes.
Number 2 for settlement. P. Srinivas Kumar.
I appear for the petitioner.
Offense. Offense.
Quashing, my lords. 98A.
498 ಏನ?
It's been settled. The parties have accepted for the settlement. Both the
Yes.
parties are present.
Copy next week only. Yes.
My lordship, because there is a matrimonial case pending, she has to go for abroad for the studies.
Huh.
That is the reason she has come from.
When?
She's.
When is she traveling back, sir? Lot of time, no problem. Yes. You will get
They
the
are
copy
all
on Monday.
Coming from Tamil Nadu.
You will get the copy on Monday. Now you sign and go, no problem.
Yes,
It is
my lord.
quashed.
Yes, my lordship.
It's settled cost, but copy of that you will get only on Monday.
Yes, my lord.
Yes.
Order to send.
Joint memo ಎಲ್ಲ ಎಲ್ಲಿದೆ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದೀವಿ sir. ಎಲ್ಲ ಹಾಕಿ. We have filed a joint memo.
ಕೊಡಿ.
Bill number.
Sunil Kumar, withdrawal, only 3. Yes. AJK 8171 ಮಾತ್ರ.
Number.
Same.
Number 5, Giridhar H.
The petitioner.
ಏನ್ ಗಿರಿದ್ದಾರೆ?
Yeah, the petitioner is being tried for the offense under POSCO and Information Act.
Poxo. Poxo.
POSCO.
Poxo.
POSCO.
పోస్కులదేం లేదు.
Ade,
Yes.
alleged the incidents was happened in 2013 January. And the complaint was filed in the year 17/9/2020. On the allegation that the act of the sexual act between the victim and the.
What was the age of the victim, sir?
She was a minor at that time.
Minor ಗೊತ್ತು, ಏಜ್ ಎಷ್ಟು?
Age 13 years.
13 years.
Yes.
Yes, sir. Now what do you want, sir?
My lord, what has happened is they have filed the report, final report charge sheet on 12/11/2020.
12/11/2020.
2020. Thereafter, the state, in fact, before that statement of PW2, who is the complainant, was recorded on 30/9/2020. At that juncture, the CD supposed to have been down.
What CD?
CD of the visual of the act of the sexual act, which came to be viral.
You have recorded the act also?
That is the allegation. And it came to be viral. After in the social media in the year 2020. Based upon that, complaint was lodged on 17th. 16th, he saw the video clipping in his mobile. On 17th, complaint was lodged. On 30/9/2020, the statement and the CD which has been.
Now, what is the ground on which you are seeking quashment of the charge sheet?
My lord.
And why did you move it for 2:30?
Because
2:30.
Why? Because day after tomorrow, the trial, they have recalled the witnesses who have been examined long back.
So
after submission of second report.
So what?
Second report was submitted without the permission of the court.
Supplementary charge sheet.
No, they say supplementary charge sheet.
Supplementary charge sheet, there is always a nivedane in the charge sheet saying that we will file supplementary if it is needed. But no permission is express permission bekagilla when that is already there.
My lord.
Next point.
Trial was commenced. Before submission of the report, trial was commenced and the evidence of material witness were recorded. And to fill up the lacuna, they have produced they have submitted the second report, wherein the statement made in 30/9/2020 and this statement recorded in the second along with the second charge sheet totally varies. And they have introduced a new character.
New character?
In the sense, a person by name Halesh was the person who has downloaded that clipping from the mobile of the complainant, and mobile was not seized. And this Halesh, the role has come into play only after the CD, when CD was supposed to be marked in evidence.
ನಾಳೆ ಏನಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅಲ್ಲಿ it is for recording of further chief of the PW1 and PW2.
So why
after
should,
no,
why should you
in
interfere
fact,
at this stage?
why? Because in fact, when the admission of the CD was in question, the trial court has allowed the PW3 to play the CD and mark and get identify the person victim in that CD after 1.5 years of the recording of the evidence, further evidence. In fact, the evidence of the victim was completed in the 31/1/2023, and the evidence of the complainant was completed on 14/10/2022, and the PW3 evidence commenced in 23/2/2022 and 9/1/2024 without seeking the permission.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ಏನ್ ನಡೆದಿದೆ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ.
ನಡೀದೆ.
Without seeking the permission, that CD came to be confronted to the PW3 despite of the objection. Now they subsequently they are seeking the recalling of PW1. There is a lacuna which I can persuade your lordship where there are earlier lacuna, how they are filling up.
What are you challenging?
Now
They have recalled the PW1 for further examination.
Yes, my lord.
That you are challenging.
Yes, my lord.
311 application ಹಾಕಿದ್ರಾ?
ಹಾಕಿದ್ದಾರೆ, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ. ನಾನು objection ಕೂಡ ಹಾಕಿದ್ದೇನೆ.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Objection allow ಮಾಡಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ to make out a case and how the lacuna has happened during the course of the trial and how, why the now
Who files the application under 311? Prosecution?
Prosecution.
What's wrong with it?
Already PW3 was deposed.
No problem. What's wrong with it?
My lord, in fact, when the objection was there and when there was a lacuna,
Even if it is to fill up the lacunae, 311 is permissible. Yes.
My submission would be the filing of subsequent.
See Supreme Court judgment in Varsha Garg, sir.
Allah, in fact, the 3 judges bench, when they have considered in Vinu by Hari by Malavi.
Vinu Bai is when can you file the additional charge sheet?
No.
And at till what stage we can interfere?
Yes.
That is 2019 SCC.
Yes,
page
ma'am.
1. Yes.
My lord, in that, in fact, there is a observation till such time the trial commences, the seeking of the further or additional investigation can be done.
Yes, can be done.
But subsequent to that, it cannot be done without the
ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿತ್ತಾ?
ಆಗಿದೆ.
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಸಪ್ಲಿಮೆಂಟರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿತ್ತು.
ಹಾಗೆ ಎವಿಡೆನ್ಸ್ ಕೂಡ ಆಗೋಗಿದೆ, ಕಂಪ್ಲೀಟ್ ಆಗೋಗಿದೆ. PW1, PW2 ಕಂಪ್ಲೀಟ್ ಆಗೋಗಿದೆ.
That's all right. Now you are challenging 311 application ಅಷ್ಟೇ.
The order of recalling.
That is there is no problem with that.
And 65B certificate is being issued by Halesh and it was not produced along with the CD. May take your lordship to only one.
No, it's too late to take me to all that. ನಾಳೆಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಈಗ?
ನಾಡ್ದು ಬೆಳಿಗ್ಗೆ.
ನಾಡ್ದಿಲ್ಲ, ಫ್ರೈಡೆ. ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಹಾಕಿರಿ. ಎಸ್. Interim order. Yes. Learned HCGP is directed to accept notice for the respondents. List on Friday.
But fresh matter.
Our Friday all fresh. Yes.
Sir, copies ಕೊಡಿ.
Latif and the ಎರಡು withdrawal in terms of now one ಅಲ್ಲ ಇದನ್ನ ಲಿಸ್ಟ್ ಕರೆದ್ಬಿಡ. Let us disperse advocates. ಕರೆದ್ಬಿಡಿ. Page wise serial number. Wherever interim orders are there, I'm going to give dates in admission matters. Where interim orders are not there, ad matra mention ಮಾಡಿ.
Serial number 190.
Troubling, sir. I'll take
129.
I'll take your matter after this.
Serial number 129.
ಒಂದು ನಿಮಿಷ. Page wise ಕರಿತೀನಿ. ಇಲ್ದರೆ chaos.
Sir.
Yes.
88 my lord, petition.
88 no interim order.
Interim order illa, but he is in custody since 16 years. The only grievance is that he is in custody my lord since 16 years.
Monday fresh matters list. Yes.
The top of the list is some timings maybe.
Fresh matters list 22 top ಅಲ್ಲೇ ಬರುತ್ತೆ. Yes.
86 my lord is.
10:10ವರೆಗೆ ಮುಂಚೆ ಬೇಕಾ? ಇಲ್ಲ ತಾನೆ? Yes.
Please.
At least after 2 weeks interim order grant earlier stands extended to the next date of hearing. 90 list after 2 weeks. No application also for interim order. Yes, 2 weeks.
91 my lord.
Bharat, 91.
Easy act.
Idea?
That's a decision.
2 weeks, yes.
Release of food grains ಇದೆ ಅದಕ್ಕೆ move ಮಾಡಿ.
Food grains, madam, food grains. List on Tuesday in the fresh matters list.
86 is also passed over.
1 minute. Yes. 92, list after 4 weeks. Yes. 92, 9th madam. Which is that one on detail order madam? PPA gada. List after 4 weeks. Yes, next.
93. Yes, madam.
Idea?
ಇದರಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಪೆಟಿಷನರ್ಸ್ ಇದ್ದಾರೆ.
2 weeks.
ಅಲ್ಲ 2 weeks ಬೇಡ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ
3 weeks.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
4 weeks.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Yes, list after 4 weeks. Interim
No,
order
no,
granted
madam.
earlier,
Next
sent
week,
to the
madam.
next date of hearing. Yes. 94.
94 also.
Also same. Yes. 2 weeks back, 4 weeks?
2 weeks, 2
2
weeks.
weeks, yes. Same 95, 96.
96 covered by ruling, ma'am.
Covered by, no problem. We'll uncover it later.
MMRD.
Huh?
MMRD case.
Interim order ilva?
Interim order.
Is that? Yes.
Date may be fixed.
Yes.
97.
97.
There is a mistake. It is being shown as NOC. We have not given any NOC.
Balasubramanian ilva?
Not issued. I appear.
Registry to delete the name of Balasubramania BN as appearing for the petitioner. Interim order idea? Monday, fresh matters list. Yes.
98. There is
Idea?
an interim order. Milords, this is a passport issue. Passport issue, the part, the
Angare.
Senate Council has already argued partly.
Passport under passport list on Tuesday.
Hello.
99? 99, list after 2 weeks. Interim order is there.
So petitioner has been
You're
suspended.
suspended. You are respondent, is it?
So one has been suspended from his work.
Ah.
So if you could list it on Monday.
No. We'll see. Interim order idea ಇಲ್ಲಿ. Petition number 1 ಇಲ್ವಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. We'll see. Yes. 2 weeks. You move it after 2 weeks. Yes.
My lord.
Vacating stay ಇದೆ.
Yes,
List-
my lord. I am for respondent, my lord.
List
I'm
list
for
on
respondent.
19th. Yes. 19th. Yes. Vacating stay ಇದೆ. Same 19th.
I'm for the petition 102, my lord. Interim order.
Interim order continue ಆಗುತ್ತೆ. But it's vacating stay ಇರೋದ್ರಿಂದ 19th. Yes.
103, my lord, I am for the petitioner, my lord.
Monday, fresh matters. Yes.
Please.
2 weeks. Interim orders continue. Next. Monday, fresh matters. Monday, fresh matters. Yes. Vacating stay ಇದೆ. ಹಂಗ 19th ಹಾಕಿ. Yes.
104 Milords, there is no interim order. Yeah, please, sir.
If there is no interim order, Monday, sir. Yes. 104 ಇನ್ನೂ ಬಂದೇ ಇಲ್ಲ ನಾನು. Yes. ಅಯ್ಯೋ 4 ಬಂದಿಲ್ಲ. 1 ನಿಮಿಷ ಮಾಡಿ. 1 ನಿಮಿಷ. 103 ಏನ್ ಮೇಡಮ್? 15th. 104 ಇದೆಯಾ? FLW. 104 ಯಾರು?
104.
ಡೆಪಾಸಿಟ್ ಮಾಡಿ 104 ಮಾಡಿದಾರ? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. 19th, yes. 105, 19th. 19th, yes.
106.
Huh? Monday.
107.
I appeal for the petition in this case, my lords. No interim order.
Interim order ಇದೆ 107.
107.
Monday, yes. 108. Monday. 2 weeks. Huh? Vehicle 19th. ಅವತ್ತು ರಿಲೀಸೇ ಮಾಡಲ್ಲ. 19th, yes.
111. 911 interim order is there.
2 weeks.
130.
Monday.
114, Lord, I am the petition, I am for the petitioner.
No interim order.
The non-compliance of section 54 Excise Act. Last time.
Order ಇದೆಯಲ್ಲ. Interim order
order
ಇದೆ.
is there. My
Yes, 2
vehicle
weeks.
is there, will know.
2 weeks, yes.
Vehicle is also there.
Vehicles. ಮತ್ತೆ ಲಿಕ್ಕರ್ ಯಾಕೆ ಕ್ಯಾರಿ ಮಾಡ್ತೀರಾ? ವೇಟ್, ಎಸ್. ಮಂಡೇ. ನೋ ಸ್ಟೇ ಎಲ್ಲ ಮಂಡೇ. ಎಸ್. ಮಂಡೇ. ಎಸ್.
119 and 120, my lords, this petition itself is not went next week, may kindly be, I'm respondent, I'm for respondent.
Vacating stay application ಹಾಕಿ ಸರ್. Yes.
Just because in the petition itself, it's apparent, my lords.
121 Monday.
122.
2 weeks. Yes, so is it 2 weeks? ಇಲ್ಲೇ ಇರೋದು Monday.
23 minutes, no entry model.
Monday.
24.
No entry model.
Monday.
25 urgent, 126.
126 days.
2 weeks. 127.
No entry model.
ಇದೇನಿದು 376?
My lord, it's an NDPS matter, your lordship. NDPS matter, my lord, only medicines were tried to be exported.
Monday fresh matters, sir.
Yes, yes.
128.
ಏನಿದು? ಹೌದಾ? Registry to list the matter before the bench before whom the matter needs to be listed. Hyphen Justice, Lordship Justice Hemant Chandan Gowda.
129.
Transfer of investigation. Fresh matter
Tuesday fresh.
ಅಲ್ಲ ನಾಲ್ಕೈದು ಸಾರಿ ಬಂತು ಸ್ವಾಮಿ.
Tuesday fresh matters.
ಮಚ್ಚು
30.
ಇದೆಯಾ?
ಇಲ್ಲ.
Monday fresh matters. ಅಷ್ಟೇ, ಬಿಗ್ ಗ್ರೂಪ್ ಯಾವ್ದು ಕರಿಬೇಡಿ.
131 ಅಲ್ಲಿ senior counsel was supposed to argue the matter. ಅದರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ. Investigation report last time file ಮಾಡಿ.
ಬಿ ಗ್ರೂಪ್ ಹೋಗಿದೆ ಆಗ್ಲೇ ಅದು.
ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು. Kindly have the matter on Tuesday or on Thursday.
Next 19th.
19th 3 PM time ಕೊಟ್ಬಿಟ್ರೆ ನಾವು.
ಎಲ್ಲ time we'll see. Yes.
So there is interim order in that matter, my lord.
This is what that senior counsel does.
Yes.
Bombay, Delhi.
ಇದ್ರದ್ದು this is a IT Act 66 and 43. Civil suit file ಆದ್ಮೇಲೆ they have filed.
We'll see. Yes, 19th.
So there is an interim order in 131, my lord.
Interim orders wherever are there will continue, madam. Don't mention. Yes. I'm also very sorry, sir. Yes. ಆಗೋಯ್ತು. No, sir. Interim order ಇದೆ. I'll vacate the interim order now. Until disposal of the petition, interim order ಕೊಟ್ಟಿದ್ದೇ ತಪ್ಪು. ಅದರಲ್ಲೂ urgency.
ಲೋನ್ ಸಿಗ್ತಲ್ಲ, ಅದ್ರಲ್ಲಿ ಅಮೌಂಟ್ ಫುಲ್ ಪೇ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ. Yes. Then we'll vacate the interim. Interim order stands vacated. Yes.
2 weeks after.
ಆಯ್ತು.
My lord, 132, my lord, I appear for respondent. My lord, is a petitioner is an ex-judicial.
ಇದೆಯಾ ಇಲ್ವಾ?
Interim order, the ex-judicial officer is the petitioner, my lord.
So
My lord, after issuing the
2 weeks.
my lord, he has not appeared with the trial court, 138%.
You respondent?
Non-respondent, I took a proclamation, my lord, to secure him. And thereafter.
They secured an interim order here.
They have secured interim.
Oh, list on 16th ಹಾಕಿ madam.
Please.
Fresh matters list. Yes.
Please.
Settlement ಇದೆ.
ಯಾವತ್ತು ಬೇಕು? Tuesday ಬೇಡ.
Respondent
Tuesday ಆಯ್ತು. Yes. ಆಯ್ತು Tuesday 4 ಗಂಟೆ ಮೇಲೆ ಬನ್ನಿ. Yes. 134 ಅಷ್ಟೇನಾ? ಎಲ್ಲ ಆಯ್ತು. Close.
number 86.
134.
86 ಯಾರು? Petitioner ಯಾರು?
134 petition.
Vacating of stay.
Where are you, sir? You should inform the party in person.
My lord, I apologize for that, my lord. I do know that some
ಯಾವತ್ತು
inconvenience happened to him.
ಶುಕ್ರವಾರ ಹಾಕೊಂಡು.
ಮುಂದಿನ ಶುಕ್ರವಾರ ಹಾಕ್ಲಾ? ನಾಡಿದ್ದು ಕಷ್ಟ. 150 ಮ್ಯಾಟರ್ ಮತ್ತೆ ಕಾಯ್ಬೇಕಾಗತ್ತೆ ನೀವು.
ಆಯ್ತು.
Yes, we'll take it on 19th.
So great.
You are there ಅಲ್ಲ?
I'm there.
Long weekend ಅಂತ.
ಇಲ್ಲ I am here. Interim order may kindly make.
That will be.
134 settlement next week.
Next week ಆಯ್ತು.
136 my lord.
Settlement
ಅಲ್ಲ, further hearing.
You want to withdraw?
ಇಲ್ಲ, further hearing.
Next week.
Is barred by limitation 468.
ಗೊತ್ತು ಅದು. That
Date may be fixed.
26th ಅಂತ ಹೇಳಿದೆ. Interim order ಕೊಟ್ಟಿಲ್ವಾ?
ಇದೆ.
ಸರಿ.
26th.
ಆಯ್ತು.
ಮಚ್ಚ
42.
I was just thinking in myself, my lord, that we must be grateful to the God that he has given to your lordship the endless energy, which we are not lucky to have that kind of energy.
Yes. ಕಳಿಸ್ಕೊಡಿ. ನೀವು ಹೋಗಿ. ಇಲ್ಲಿಂದಾನೆ ಮನೆಗೆ ಹೋಗ್ಬೇಕು ಅಂತ. ಎಸ್. ಯಾವ್ದಾದ್ರು ಅರ್ಜೆಂಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿದ್ರೆ ಡೆಲಿವರಿ ಆಗಿಲ್ಲ.
The registration of an FIR under section 409 arising out of a civil contract between the parties. The chief ground on which the petition is filed is that it is purely a civil dispute and there is a alleged breach of agreement, and it cannot give rise to 409. But I'll briefly state before your lordships the facts, which really is as brief as possible. There was an agreement between the petitioner, who represents a company known as Zonta Infratech Private Limited.
Yes.
He is the managing director of a company known as Zonta Infratech Private Limited. But this company was awarded with several contracts by several municipal corporations for waste management, which included Bangalore as well.
Yes.
Now, the second respondent before your lordships is a German national. He also has a company, and taking looking at the business activity of the petitioner company.
The complainant is a German national.
Complainant is a German national. That is the second respondent, Patrick Dieter.
Yes.
Now he invested money in the company that is Zonta Infratech Private Limited.
Zonta is owned by whom?
Zonta is a private limited company. Managing director is the first petition.
Zonta. You manage first petition is the MD.
Yes.
Yes.
But the investment is as follows. Shortly, I'll just state before your lordships. He invested, it was not a case of borrowing, 1.5 million euros in the
0.5 million euros.
In the form he invested in lieu of shares being allotted to him to the extent of 16,667. Then, there was also, he lent 2.5 million euros. 1.5 million was by way of share subscription. 2.5 million was a debt facility which was extended to the petitioner.
Oh, 1 second, madam.
But there was some difficulty in working out this payment on account of COVID-19 and other related issues. So we for the first time received a notice at annexure page 113 on 14/3/2022 by the council. In that, the chief grievance was that we had failed to repay back the debt facility which was given to him. That was a grievance. But in the meanwhile, he had also, I must bring to lordship's notice, apart from these two facilities, given a guarantee to the bank as a standing letter of credit was given, which he was responsible. The grievance was in that legal notice, which were the beginning of this entire prosecution. 14/3/2022, they also said you had promised us that you will relieve us of that letter of credit. You have not done so. But we replied back to them, informing them that that we had made efforts to ensure that the loan was repaid and that the letter of credit was also replaced. There was for the first time a complaint filed before the Common Park Police Station, not this. Then there, they forced us to enter into a settlement.
Forced you?
Forced us. That is our contention. That is our statement. And therefore, for the second time, it is known in fact as a settlement agreement at page 119 Annexure G on 6th October 2022. A settlement agreement.
27,500 euros.
Yes. 27th to be paid so and so, so and so. Pursuant to which, Lords, there were some Lords, mutual obligations between the parties, pursuant to which the following sum was paid. 27,500 euros was paid on, Lordships may kindly note this, 6/11/2022. And 30,780 euros were paid on 9/1/2023. This payment was actually made pursuant to this.
Yes.
Now, Lords, insofar as the grievance was SLBC, that is a standing letter of credit which he had given to the bank. But I informed them that I had written to the bank stating that you please relieve him of that standing letter credit. I will give my properties. The bank, Lord, I have produced all those correspondence as Lord's annexures to the writ petition. The bank informed us that we will consider it and the matter was in process. Obviously, there was delay. It is this background, Lord, the complaint is filed.
Page.
Yes. The complaint, Lordships will get it at page, Lords,
Private
28. It is a, yes.
No, it's a
complaint given to the jurisdictional police, Kavan Park Police Station for the second time. Obviously, first time they gave, there was a settlement.
No, it narrates the settlement agreement also at page 26. That earlier settlement agreement was there.
Yes, yes.
That
Now-
has been breached and close to 32 crores is what is remaining to be paid.
32,000, yes. Now, at page 28, Lordships will kindly see page 29.
Just to balance payment, 32 crores.
Now, it according to them, Lords, about 82,076.3 euros to be paid.
Euros, that's
Now,
what.
Lord, I'll exactly.
That's all right. Yes.
Give the figures to Lords.
Yes.
Now, but kindly see the tenor of that complaint itself. At page para 5, page 30.
13.
30.
It's pertinent to note.
According to, it starts from the word according. Lordships get accordingly. Page 30.
30.
Para number 5.
Then previous paragraphs.
I'm sorry, Annexure A1.
No, page starts from para 5, but where are 1 to 4?
No, 1 to 4 previous.
Oh, it's at page 29. Madhyadalli ಏನೋ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ. Yes, anyway.
Let's get para 5. I just wanted to read that.
According to settlement agreement.
Emphasis on that. According to the settlement agreement dated 6th October 2022.
It's at page 30.
Yes, page 30. 27,500 euros were to be paid by Mr. So-and-so to so-and-so upon the signing of settlement agreement. And balance of so-and-so to be paid before 3rd November 2022. Along with it, so-and-so were to be paid to Mr. So-and-so towards travel and accommodation expenses. And it was categorically mentioned that Mr. Zonta Infratech Private Limited shall make every endeavor to release the SBLC not later than 30th November 2022. It is pertinent to note that the settle agreement dated 6th October 2000 was entered into with the sole intention to breach the trust of Mr. So-and-so. It is evident through the conduct of RPLI. Till today, SBLC is not released and he has failed to pay the assured amounts mentioned in the settlement agreement. Mr. So-and-so gained the trust by entering into a settlement agreement with the sole intention to breach this trust and cause wrongful gain to himself and wrongful to Mr. So-and-so. Thus, clearly 409 is attracted. He is the entire gist of the complaint. Then he says 409 fiduciary relationship with the company others. Now, this statement is also not correct because I have just stated before your lordship, pursuant to the settlement agreement, 27,500 euros was paid on 6/11/2022 and 30,780 euros on 9/1/2000.
Now it is still at the stage of investigation.
Or stay, interim stay. Now, one other thing I want. But this statement is also not correct. Now, second aspect is their grievance is SBLC. I have not yet got, I could not get it released. May I request Lordships to kindly permit me to read just a few lines of this letter at Lord's Annexure H, page 124. They had given SBLC land, that is letter of credit agreement, letter, which we say, at the out, my lords gets Annexure H at page 124. At
28
the
July
outset, we
22.
thank you, the support exponents. This letter is in relation to the subject matter cited above. And you on at various points of time, as you are aware, we had proposed for replacement of SPLC with the personal properties of Mr. So-and-so, that is the petitioner, last year, and reiterate our proposal once again. In this regard, we request your good office to assist us in replacing the existing SPLC with the properties of director so that our obligation towards Boyer so-and-so, that is the petitioner, is completed from our end. They replied back saying that we will work on that, etc. Renewal of first, that is the next page they have replied back. It is not that I did not make any efforts to honor the settlement agreement. Therefore, my lords, my submission before your lordships is prima facie to attract the provisions of 409. There must be at least minimum allegation that, my lords, that there was some property entrusted to me, which I have misappropriated, my lords, committed criminal breach of trust in violation of that. Not in fact, minutes of meeting, I will just show before your lordship.
Ingredients of 409.
409, right? The
405 is the ingredients.
405 is to be attracted for the purpose. They say agent. I acted as an agent of the company and I misappropriated. But in fact, not at page 130, lordships will kindly note. For a moment, in fact, lordships will kindly see page 130. These are the minutes of the meeting, lords. These are the minutes of meeting dated 30th November 2021. In which I present the managing director, second director and member is the complainant himself. In that they have recorded everything, audit documents are recorded, plus we have reviewed the business progress, which shows, kindly permit me to read, the second and third point. The details of new orders which were bagged by the company from municipal corporations of Almora, Kollam, Kannur, Ranchi, Tambaram, Tiruvannalai, Trichy. The status of various projects undertaken by the company under waste collection and transportation, waste disposal solution, and waste processing, so and so. Key financial of the company from the financial year 2020, all this came to be approved in his presence. The question of I misappropriating anything does not arise. Therefore, my respectful submission before your lordship says that this is clearly a case where there is a breach. Of course, there are claims and counterclaims. I must bring to lordship. We have initiated arbitration proceedings. Yes, we have initiated. We have filed an application for appointment of an honorable of an arbitrator before the Honorable Supreme Court of India. Honorable Supreme Court has issued notice upon them to give their statement about the. I'll give the detail. Yes, I'll just. Two judgments I want to cite. Lordships are aware of this proceeding, but Sarabjit Kaur. Sir, I'll just give the copy. Copy question. I'll just give it. I'll read it. 2023, Part 5, SCC page 360. But I propose to rely upon para 13.
Yes, sir.
But a breach of contract does not give rise to criminal prosecution.
Yes, you can read.
A breach of contract does not give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep a promise will not be enough to initiate criminal proceedings. Yes. Then, lords, in that very paragraph, last few sentences, their lordships say this word, and I will permit lordships with para 13. The entire idea seems to be to convert a civil dispute into a criminal and put pressure on the appellant for return of amount allegedly paid. The criminal courts are not meant to be used for settling courts or pressurize parties to settle civil disputes. Wherever ingredients of criminal offences are made out, criminal courts have to take cognizance.
That's old.
I'm sorry.
That's an old judgment.
Yes, old judgment. Now, Lord, the one more judgment of Lordship Justice.
That is 2024 A.M. Mohan versus State of Karnataka, I guess.
So this is Lord's Naresh Kumar.
Yes, Naresh Kumar is also old.
So that Naresh Kumar is by Lordship Justice Sudhanshu Dulia. They are not, they quote Sarabjit Kaur. I mean, they rely upon, I just point out.
That's
I'll not read it, para 7. I'll just.
Yes.
Sorry, it's Sarabjit Kaur. Sorry. Oh, it's their extra copy. I didn't see. Oh, whatever.
Yes. Ashok.
So we have not been able to keep match with lordships about the judgments. We thought this is the latest one, but there's one more which has come.
Latest is 2024, one
Yeah. No, there is one more-
delivered in
Yes, there's
April.
one other aspect not which I must bring to lordship's notice
Hmm.
is the non-arraying of company as an accused.
That is the reason for grant of an interim
Yes,
order.
yes.
SK
Case-
Alag and
Yeah, SK Alag
other
is,
judgments.
I
yes.
want to rely upon that. SK Alag.
No, SK Alag, Maqsood Syed
Yes, yes.
and the subsequent Sunil Bharati Mittal. they
All of them.
that's
SK
enough.
Alag is what we have.
SK Alag is what is quoted in the interim
Yes.
order. Yes,
Part of the compilation.
yes, yes.
Madam.
Kodi.
The last aspect note which I must bring to lordship's notice is the background, last judgment in that compilation. But I have only cited, I don't want to burden lordships with all the other.
SK Alag.
SK Alag.
Hmm.
Alag to say- yes, to say that, my lords, in the absence of the corporate company being made a party, of course, the proceedings there, the court proceedings. Here, he could not have made, he himself is the director of the company. That is the aspect.
Yes.
Lastly, my lords, the fact that, my lords, he had earlier gone to the police station by filing a complaint and there a settlement was arrived at. But that clearly shows that this is certainly an attempt to get the matter settled through the process of criminal proceeding, which is impermissible.
Right. Yes, sir.
But, your lordships have relied upon this judgment for various purposes. Nitesh Kumar Jha,
Ah, yes,
my lord, paragraph 34,
yes.
my lord, their lordships say that the same set of facts and circumstances may give rise to a, yes.
Latest I have on Friday pronounced,
Yes,
a singular act may give rise to two sets.
Two
One
sets.
civil case and another
absolutely,
criminal
my lord,
case.
absolutely.
But that is why it depends on facts. of
Therefore,
each
my lord,
case.
what is to be seen is the complaint. Let us see, my lord, complaint and the documents referred to in the complaint. My lord, let us read a few paragraphs from the complaint. My lord, we are sorry, we are taxing your lordship's time because I will have to take your lordship through some of these
Then
paragraphs.
We'll continue,
Yeah, we will, my lord.
not now.
Anytime, your lordship's convenience.
Shukrara togla.
Friday? Very well.
Shukrara.
Because I will have to make out a
Shukrara
case.
you may have to wait because
Yes.
avattu 150 ಇದೆ.
We will wait, my lord.
ಅವತ್ತು 150 cases ಇದೆ ಅಂತೆ.
150
We
ಇದೆ.
will wait, my lord. We will-
You come at 4 o'clock.
Ah.
Yes.
If any other day lordships what proposed to have, where lordships are less, little bit compared.
Less andre only 22nd.
No, then lords Fridays.
It is 22nd. That doesn't matter. We can take. 22nd is also
Fine.
fine with us.
22nd, 4 p.m.
Provided-
Monday.
Very,
Monday, though there will be 200, 300. I'll finish it by 4.
Very well.
Yes.
By 4 o'clock, we will.
If barade 4 o'clock bade. Finish all your work and come.
Very well.
Yes. Heard the learned, ಅದ್ ಬರ್ಕೊಂಡ್ಬಿಡು. And I'll pass the order.
Very well.
Yes.
There is an interim order, probably my learned.
Yes, that will continue.
Good.
That will get vacated only as a
Yes.
last thing.
Lordship, my lord, in item 147, I seek leave of the court to file written submissions and list of authorities. ma'am.
Please do, madam.
Problem.
Yes. Which one? The one that is now dictating orders care?
Yes, ma'am.
In that one,
In-
the criminal case?
Yes, ma'am.
All right, yes.
Problem.